Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. In this session, we shall discuss all the PYQs from Indian polity asked by the UPSC in the civil services examination during the period 2013 to 2024. I will also be discussing some important PYQs which were asked in 2011 and 2012 as well. Why? I'll tell you the reason when we will discuss those PYQs. This is a very important lecture, particularly for those who are targeting Prelims 2025 as well as those targeting 2026 or beyond. If you're targeting Prelims 2025, attend this session in its entirety. We will not only discuss the PYQs, we will also discuss the concepts related to these questions. So this will be helpful for your revision. Those attempting prelims in 2026 or beyond, this is an important session. Why? Because you will find an answer to this question: how to study, how to prepare for this exam, what sort of questions can be asked in the examination, what sort of questions have been asked in the examination, so that you can prepare accordingly. And this document also is very important. That is why I will be sharing this PDF after the class is over on my Telegram channel. The link to join the Telegram channel is provided in the video description. Please download the PDF from there. Also, when we look at PYQs, this session is going to be of 3 to 4 hour duration, but please stay with me till the end. I promise you will not regret. I promise this is going to be extremely helpful for your preparation. Let's get started, and let's first look at an important announcement, because I'm told that this offer ends today, means tonight. If you want to prepare with us for your civil services examination, this is the right time to subscribe to our UPSC courses, should you wish to subscribe, because the 15-month course is available now at 22,999, which I'm told will end tonight. But whether you're watching it today or you're watching it later, at any point in time, should you wish to subscribe to our UPSC courses, go to our website, take a look at the various courses that we offer, use this code IAS English, and automatically you will be shown the lowest subscription fee. Also, what I've done in the session, I have divided these PYQs not in terms of years these questions were asked, but in terms of the topics. So first we will discuss topics related to the basics of Indian polity, preamble, union and its territory and citizenship, then fundamental rights, DPSP's fundamental duties, one by one. And I will also urge you to participate with me and answer these questions in the chat box, so that I can get to know whether your preparation is on the right track or not. Clear? So let's get started. Let's look at question number 1. This question was asked in Prelims 2021. What was the exact constitutional status of India on 26th January 1950 when the Constitution was enacted? When we look at preamble, preamble is like the identity card of the Constitution, as Nani Palkhiwala would say. It is the philosophy of the Constitution. If you want to understand what Indian Constitution is all about, without reading all the articles, all the parts, all the schedules, you just need to go through the preamble, and preamble will tell you the philosophy of the Constitution. But at the time of the commencement of the Constitution, preamble said, "We, the people of India, having solemnly resolved to constitute India into a sovereign, democratic republic." Because the term socialist and secular, these were added later by the 42nd Constitutional Amendment Act. The year was 1976. And during this constitutional amendment, another word was added: integrity. Where? Because preamble tells us about 4 things. 1, it creates a legal fiction. We the people. It says that this Constitution has been enacted by the people of this country. Although which is not true, it was not enacted by the people themselves, but it was enacted by the members of the Constituent Assembly. But a legal fiction was created to mean that this constitution was enacted and adopted by the people of this country, we the people, which means what is the source of authority of the constitution? That's the people of this country, because popular sovereignty lies with the people. Second, it tells us what is the nature of the Indian state: sovereign, socialist, secular, democratic republic. But at the time of the commencement of the constitution, socialist and secular were not mentioned. These got added later. Third thing that preamble tells us is what are the objectives that we want to achieve through this constitution: justice, liberty, equality, fraternity, dignity, ensuring unity and integrity of the nation. So this integrity term was also added by the 42nd Amendment. And the last thing that preamble tells us is the date of adoption. What is the date of adoption of Indian Constitution? 26th November 1949. Let's look at question number 2. The mind of the makers of the Constitution of India is reflected in which of the following? Preamble is like the preface to a book, the preface to a novel, for example. What does that preface tell us? It tells us what is this book all about. So what is preamble telling us? What is this constitution all about? But preface not only tells us about the book, it also tells us about the mind of the writer, the author. What was going on in the mind of that author when he was writing that book, when she was drafting that book? Similarly, what was going on in the minds of those who were part of the Constituent Assembly? That we will get to know by looking at the preamble. So if the preamble talks about liberty, equality, fraternity, justice, which means the makers of the Indian Constitution, their thought process was aligned to these objectives. And this is something which Supreme Court also has said. Supreme Court has said preamble is a document which can be used to unlock the minds of the makers of the Constitution. So the question asked in 2017, the mind of the makers of the Constitution of India is reflected in which of the following? The answer is A, the preamble. Right? Let's look at another question. This was asked in 2020. The preamble to the Constitution of India is, now is preamble part of the Constitution? Supreme Court had said in Berubari Union case that it is not a part of the Constitution. But then in 1973, in Keshavananda Bharati case, Supreme Court said, no, preamble is part of the Constitution. Why? Because in Keshavananda Bharati, the Supreme Court was told, which was not communicated to the Supreme Court in the Berubari Union case, that just like any other provision of the Constitution, preamble was also discussed by the Constituent Assembly. Just like any other provision of the Constitution, preamble was also voted upon by the members of the Constituent Assembly. In fact, the last item to be added to the Constitution was the preamble. Now, sir, why was preamble the last item added to the Constitution? This was to ensure that since preamble is the philosophy of the Constitution, this should be aligned with the other articles that are there in the Constitution. So other articles should not be incompatible with the preamble. That's why preamble was the last item added to the Constitution. And when this was communicated to the Supreme Court in Keshavananda Bharati case, that just like any other part of the Constitution, preamble was also discussed, voted upon. In fact, it was the last item voted upon by the Constituent Assembly. Supreme Court said preamble is part of the Constitution. In fact, you would know that preamble is based on the Objectives Resolution, which was introduced by Pandit Nehru in the Constituent Assembly and adopted by the Constituent Assembly on the 22nd of January 1947. So that Objectives Resolution was adopted on 22nd January 1947. But preamble is based on the Objectives Resolution. So preamble was the last item voted upon by the Constituent Assembly. But you would also know that preamble is not enforceable in a court of law. Then what is the significance of preamble? We say the significance of preamble is that it is used to interpret the provisions of the Constitution when the language is found to be ambiguous. For example, in 2017, a landmark case was heard by the Supreme Court. The case was K.S. Puttaswamy versus Union of India. What was this case all about? This case was about right to privacy, whether right to privacy is a fundamental right or not. Because the previous judgments of the court, for example, an 8-judge bench in 1962, previously another bench in 1954 had said that privacy is not a fundamental right because it is not explicitly provided by the Constitution. But over a period of time, some smaller benches of the Supreme Court had said that right to privacy is a fundamental right. In fact, it is a fundamental right under Article 21 of the Constitution. For example, one important case was Salvi v. State of Karnataka, 2010, where Supreme Court said that right to privacy indeed is a fundamental right under Article 21 of the Constitution. But when Aadhaar was introduced in India and Aadhaar law was passed, this was challenged in the court, saying it violates privacy because you are sharing your biometric information, biometric details. Matter went to the court. Supreme Court said, first we will decide and rule whether right to privacy is a fundamental right or not. And a 9-judge bench of the Supreme Court decided by a majority of 9-0. That means all the 9 judges who heard this case, they said right to privacy indeed is a fundamental right. But what made Supreme Court say this? One, the reason was Supreme Court looked at the preamble. And Supreme Court said one of the objectives, as mentioned in the preamble, is the dignity of an individual. This dignity would not be possible unless and until we provide privacy to an individual. That is why right to privacy is a fundamental right under Article 21 of the Constitution. And you would also note that Supreme Court in that case talked about 2 kinds of privacy: informational privacy and decisional autonomy. But what is the question asking? The preamble to the Constitution of India is a part of the Constitution but has no legal effect. This is wrong. Not a part of the Constitution, it is wrong. A part of the Constitution and has the same legal effect as any other part? No, because it is not enforceable in a court of law, but fundamental rights are. So it is part of the Constitution, but it has legal effect. But just like other fundamental rights, other parts of the Constitution, no. It is a part of the Constitution, but has no legal effect independently of the other parts. Which means independently, you can't go to the court and say preamble has been violated. But the objectives which are mentioned in the preamble, for example, the objective is political justice. For that we have fundamental rights. If fundamental rights are violated, you can go to the court. So preamble is part of the Constitution, but has no legal effect independently of the other parts. It is dependent on other parts of the Constitution, because it is not independently enforceable in a court of law. So D is the right answer. Great. Okay. Which one of the following objectives is not embodied in the preamble to the Constitution of India? Preamble also talks about, as I told you, objectives that we want to achieve through this Constitution. And what are these objectives? First is justice. Social, economic, political. Liberty. Liberty of thought, belief, and expression. Economic liberty is not something which is mentioned in the preamble. Economic justice is mentioned, but not liberty. Liberty is in terms of thought, belief, and expression. That is why B becomes the right answer. Constitutional government means what? What do we mean by constitutional government? And for that, what do we mean by constitutionalism? In the words of American political theorists, for example, John Locke. Constitutionalism means that governments should and can be limited in their powers. Look at the paradox. What is a constitution? Constitution is the supreme law of land. What is the constitution? Constitution is a document which tells us about how the state will be governed. It allocates roles and responsibilities to different organs of the state, for example, legislature, executive, judiciary. This is what a constitution is. So this constitution first has to give power to the state, to the government. But then this constitution has to also impose limitations on the powers of the government, because if there are no limitations on the powers of the government, we may end up with a despotic rule. For example, if the people of this country were all angels, maybe we don't even need the constitution because angels can do no wrong. What if people are not angels, but those who are part of the government, they are angels? Modi ji is an angel. Amit Shah is an angel. Then we don't need to keep limitations on the powers of the government because the government is full of angels. Angels can do nothing wrong. But neither are the people angels, nor is the government full of angels, which means first we have to empower the government and then impose limitations on the government. That is what John Locke says means constitutionalism. Governments should and can be restricted in their powers, limited in their powers. And the legitimacy of the government will depend upon whether that government is observing those limitations. For example, one way in which we say constitutionalism is implemented in India is through rule of law. If there is no rule of law in a particular state, what do we say? That there is no limitations on the government. The government is illegitimate. So the legitimacy of the government depends upon whether it is observing those limitations or not. So Constitution primarily imposes limitations on the powers of the government. And that is what constitutional government is. So what is a constitutional government? A government limited by the terms of the Constitution. Clear? Okay. Consider the following statements. A constitutional government is one which places effective restrictions on individual liberty in the interest of the state authority. For example, fundamental rights. We say we follow constitutionalism because we have fundamental rights. And what are these fundamental rights? Fundamental rights are basically limitations on the powers of the state. For example, look at the wording of fundamental rights. The state shall not deny equality before law. The state shall not discriminate. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this. The state shall not do that. That means all these fundamental rights are negative obligations. These are restrictions on the powers of the state. State don't interfere with the liberty of an individual. So Constitution imposes limitations on the state, not on the individual citizens. Which means constitutional government is what? Which places effective restrictions on the authority of the state in the interest of the individual liberty. This statement is correct. First statement is incorrect. Because constitutional government by its very sense means a government which is limited by the terms of the Constitution. And there are limitations imposed on the powers of the government. That means on the authority of the state, there is a limitation. Which means which of these statements given above are correct? B, 2 only is the right answer. A constitutional government by definition is, now this is an easy question for you because we have explained. Is it a government by legislature? Is it a popular government? Is it a multi-party government? No, it is a limited government. That means a government which is limited in its powers. Which one of the following statements best reflects the chief purpose of the Constitution? Now, there are certain questions asked in the examination where if you look at the statements, almost all the statements make sense. But then you have to revisit the question. What is the question asking? And here the question is asking which one of the following statements best reflects. Although all these statements may reflect the purpose of the Constitution, but what is the statement which best reflects the purpose of the Constitution? Again, constitutional government, which means it defines and limits the powers of the government. That is the chief purpose of the Constitution. Yes, others may also make sense, but you have to pick the right answer, which means the most appropriate answer, which means the question says, which of the following statements best reflect the chief purpose of the Constitution? And that is a constitutional government, the government which has limited powers. That means it defines and limits the powers of the government. Clear? Great. With reference to India, consider the following statements. Now, this is a question on citizenship. There is only one citizenship and one domicile. Now, what do we mean by domicile? Residence plus intention to reside for an indefinite period. That is what we call domicile. And is this term domicile defined in the Constitution? It is not defined. Supreme Court in its various judgments has said that we do not have different domiciles. We have one domicile, which means your domicile within the territory of India. The maximum thing that we can use domicile for is to get seat in an educational institution. That means in some states there can be reservation on the basis of domicile, but strictly in terms of getting admission in an educational institution. Otherwise, we have a single citizenship and we have a single domicile, which means you are a citizen of India and you are a domicile within the territory of India. So there is only one citizenship and one domicile. This statement is correct. A citizen by birth only can become the head of the state. Who is the head of the state? The President of India. What is the qualification in order to contest election to the post of the President of India? You should be a citizen of India. You must have completed 35 years of age. Does the Constitution of India say that you should be a citizen by birth and not citizen by descent or registration or naturalization? No. Whoever is the citizen of India, you are eligible if you have completed 35 years of age to become the President of India. Unlike United States, for example, that is why Elon Musk cannot become the President of the United States. Because to contest election to the post of the President of the United States, you should have been born on the soil of the United States. And he was not born on the soil of the United States, possibly born in South Africa. So he can't contest. But in India, a citizen by birth only can become the citizen of India, can become the head of the state? No. Any citizen, whether you are citizen by birth, naturalization, registration, descent, which means can Sonia Gandhi become the President of India? Yes. Can she become the Prime Minister of India? Yes. But why was she not allowed to become the Prime Minister in 2004? As Dr. Subramaniam Swamy says, I blocked her prime ministerialship. Well, that is not correct because APJ Abdul Kalam, the then president, writes in his autobiography that I had no hesitation in swearing her in as the Prime Minister, but then the Congress Party and others, they recommended Dr. Manmohan Singh instead. A foreigner once granted citizenship cannot be deprived of it under any circumstance. This is incorrect because once you have been given citizenship, whether, and we are talking about a foreigner can be given citizenship through registration, naturalization, and for that you have to satisfy various conditions. But if you have acquired Indian citizenship through fraud, through concealment of material facts, then your citizenship can be deprived. So there is one aspect called deprivation. So there are three ways by which you can lose your citizenship according to the Citizenship Act of 1955. By renunciation, if you voluntarily give up your citizenship. By termination, if you have taken up the citizenship of another country without giving up your Indian citizenship. And third is through deprivation. So which of these statements given above are correct? A, one only is the right answer. Prelims 2020, one common agreement between Gandhism and Marxism is, there are some who say both Karl Marx as well as Mahatma Gandhi, they were anarchists. Whether that's a correct statement to make or not, I don't want to get into that debate. But both of them had one common ideology. For example, Mahatma Gandhi talked about Ram Rajya. And Karl Marx talked about communism. What happens in communism? Karl Marx says there is a cyclical nature of history. For example, we started off with primitive communism. It was a beautiful egalitarian society where there were no classes. There were no haves and have-nots. Everybody was equal. There was no concept of private property. But then it is this beautiful egalitarian society, the primitive communism, which got destroyed. And then we entered into different stages of history. For example, ancient society, feudal society, capitalist society. And in all these societies, Marx says there have been two classes which have emerged, haves, have-nots. For example, in feudal society, landlords and serfs. In capitalist society, the bourgeois and the proletariat. Karl Marx says that there has to be a revolution. That's why he gives a slogan along with his friend Friedrich Engels. All the workers of the world, unite. Let's unite and let's overthrow this capitalist system. And once that capitalist system will be overthrown, we will enter into a stage called socialism or socialist state. But socialism is a preparatory stage because for Karl Marx, the final objective is communism. This is where, according to Marx, the history will end. Because history is a cyclical nature. From primitive communism, ancient society, feudal society, capitalist society, socialism and communism. This is where the history will end. This is where the history will rest. This is where there will be no classes. And this is where according to Karl Marx, state will wither away, where there will be no state. What is communism for Karl Marx? That is Ram Rajya for Mahatma Gandhi. That means the final objective is the stateless society. Because in communism, there is no state. Everything will be controlled by the people themselves. That's the answer to this question, question number 10. Question number 11, which one of the following in Indian polity is an essential feature that indicates it is federal in character? Now listen to me carefully. Are we a federal polity? Do we have a federal constitution? Yes. Why? Because Dr. B.R. Ambedkar says that we have a federal polity, a federal constitution. But despite that, Dr. Ambedkar says, I have used the phrase, India, that is Bharat, shall be a union of states under Article 1, Clause 1 of the Constitution. Why? Because unlike United States, in India, there was no agreement between states to create India. India was already there. So India was not created because the states got together through an agreement, through a treaty. For example, what do we mean by federalism or federal polity? This term federalism is derived from the Latin word fidus, which means treaty or an agreement. That means you create a federal state, a federal polity, when the states come together through a treaty, through an agreement to create that political entity. But what exactly do we mean by federalism? There is no proper definition either. Then what do constitutional experts do? They take a look at the US Constitution, which is considered to be the oldest federal constitution of the world. They take a look at the US Constitution and match the Constitution with the Constitution of the United States. If it matches, it is federal. If it doesn't, then it is something else. And there are 5 important characteristics which make US Constitution federal. What are these characteristics? Number one, dual government. That means one government at the center, one government in the states as well. Second, some powers will be allocated to the center. Some powers will be allocated to the states. There has to be a written constitution. Constitution should be rigid as well and supreme as well. And independent judiciary. Judiciary should be independent. Any constitution which follows these 5 characteristics can be said as a federal constitution. For example, India, we have a government at the center, we have government in all the states. For example, we have the government in Tamil Nadu, we have the government in Karnataka, we have the government in UP. There is distribution of powers, for example, as envisaged by Schedule 7 of the Constitution. Union list, state list, concurrent list. We have a written constitution. Our constitution is supreme. It's the supreme law of land, but it is also rigid. Now listen to me carefully. What do we mean by rigidity of the constitution? Rigidity of the constitution does not mean that constitution is very difficult to amend or impossible to amend. Rigidity means if at all you want to change the constitution, modify the constitution, amend the constitution, it has to be a joint act. Joint act between center and states or between union and the states. That means union unilaterally should not amend the constitution. States unilaterally should not amend the constitution. If at all you want to make changes to the constitution, states and the union, they have to come together. And if at all there is a dispute between the union and the states, who will resolve that dispute? Judiciary. Judiciary has to be independent. That means it should neither be under the grip, control of the union nor the states. It should be independent. These are the characteristics which make a constitution a federal constitution. Although in India, we say that our constitution is predominantly quasi-federal. It is not completely federal. It has a mix of federal features as well as unitary features. That is why some experts say Indian constitution is federal, but with some unitary features. Others say Indian constitution is unitary, but with subsidiary federal features. Some say Indian constitution is neither unitary nor federal. It is quasi-federal. But whatever it is, we have said that Indian constitution is federal. Why? Because also Supreme Court said in 1994 in S.R. Bommai versus Union of India that federalism is part of the basic structure of the constitution. Now let's look at the question. Which one of the following in Indian polity is an essential feature that indicates that it is federal in character? Indian polity is federal. The independence of judiciary is safeguarded. The union legislature has elected representatives from the constituent units. The union cabinet can have elected representatives from regional parties. The fundamental rights are enforceable by a court of law. What do you think is the answer? The answer is A. Independence of judiciary is safeguarded. Because one of the most important characteristics of a federal polity is the independence of judiciary. Right or wrong? Any questions as of now? Okay. Which one of the following is not a feature of Indian federalism? There is an independent judiciary in India. It is a feature of federalism. Powers have been clearly divided between center and the states. It is a feature of federalism, Schedule 7. The federating units have been given unequal representation in the Rajya Sabha. For example, in case of United States, the upper house is known as the Senate. And in Senate, we have equal representation. In a sense, every state, regardless of your population, you will have 2 representatives in the Senate. But in India, we don't follow that. because states are given unequal representation in the Rajya Sabha in proportion to their population. That is why UP has 31 MPs in Rajya Sabha. Tamil Nadu has 19. Telangana has 7. Andhra Pradesh has 11. So on and so forth. It is the result of an agreement amongst the federating units. No. Because I told you, federalism primarily means what? It is derived from a Latin word, fidus, which means agreement or a treaty, which means you are creating a federal entity because of a treaty, because of an agreement amongst the states. But Indian state was not created because of an agreement or because of a treaty. That is why D is the right answer. This question was asked in 2021. Now, I don't know whether you have followed this question or not, whether you have read this question or not, but I want you to read this question carefully. This is a conceptual question, beautiful question asked in 2021, and let me know in the comment section what is the right answer. Which one of the following best defines the term state? I will give you a hint that this is not the state under Article 12 of the Constitution or under Article 36 of the Constitution. What is the state? Indian state, the Pakistani state, the state of United States. It's a political entity. And what is the best definition of the state? Group of people will come together. They will permanently occupy this territory called India. But this territory has to be sovereign as well. Indian state is sovereign because we can take any decision, we can unmake any decision without interference by any foreign power from any foreign country. We are sovereign in terms of our decision making. And we need an organized government. If these characteristics are met, we say it is a state. Now listen to me carefully, which means the answer is A. Now listen to me carefully. That does not mean that if there is a monarchy, it is not a state. It doesn't matter what is the form of government that you have, whether it is monarchy or democracy, whether it is presidential form or a parliamentary form. If there is a group of people who are coming together and they occupy a definite territory, and this territory has its own sovereignty. For example, can we say Palestinian state? No, because it does not have the sovereignty. It is not even recognized by the majority of the countries of the world. That means a colony may not be a state because it does not possess sovereignty. That is why A is the right answer. A politically organized people of a definite territory and possessing an authority to govern them, maintain law and order, protect their natural rights, safeguard their means of sustenance. This may be the role and responsibility of the government later, but that is not what constitutes a state. A number of persons who have been living in a definite territory for a very long period of time with their own culture, tradition, and government. It is not the political concept of the term state. It is not the political definition of this political term called state. A society permanently living in a definite territory with a central authority. Now, what if there is no central authority? There is a decentralized form of government. Can we not call it a state? So is the characteristic necessarily that there has to be a central authority? No. That means which of the following best defines the state? This is the best definition of the state. A is the right answer. Okay. Democracy's superior virtue lies in the fact that it calls into activity. This was the question asked in 2017. There is a Turkish proverb. The trees started disappearing from the forest, but the trees still kept on electing an axe because the axe was clever. Because it convinced the trees that since my handle is made up of wood, I belong to the trees. I am one amongst you, so you keep on electing me. That means this axe, which has a wooden handle, is making fool of the people. Democracy's superior virtue is that it calls into activity the intelligence and character of ordinary men and women. Now, intelligently, we have to ensure that we are electing the right set of people in democracy. Because what is democracy of, after all? As Abraham Lincoln would say, the government of the people, by the people, for the people. So we have a democracy because people choose their representatives. But how do you choose your representatives? For that, you have to be intelligent. You have to choose those people who will be able to govern you better. And then it also tests the character of the people. Will you be given in by the freebies, by the bribes offered by the political parties and their candidates? Or will you independently make a choice and decide which is that party or who is that individual who is going to best govern us, who is going to best represent our interests in the parliament and the state legislature? That's the virtue of democracy. So democracy's superior virtue lies in the fact that it calls into activity the intelligence and the character of ordinary men and women. The method for strengthening executive leadership, is that democracy all about? Democracy is about getting people to elect, and these people will govern you, will make rules for you, laws for you, and govern you. Does that mean the purpose of governance is that we want to strengthen the executive leadership, or do you want to keep the leadership under check? Popular sovereignty is with the people. Ultimate power is with the people. A superior individual with dynamism and vision. In democracy, we don't choose a leader. We choose representatives, and these representatives then choose a leader. A band of dedicated party workers. Even if you have a dedicated party workers, it can be a feature of a political party, but not of a democracy. So democracy's superior virtue is A, is the right answer. Right? Great. Let's look at another question. A parliamentary system of government is one in which all political parties in the parliament are represented in the government. Simple term, whenever you hear this phrase, parliamentary form of government, you should keep in mind that parliamentary form of government means Council of Ministers are responsible to Lok Sabha. Or at a broad level, we can say Council of Ministers means government is responsible to Lok Sabha. Lok Sabha means legislature. Or at a broader level, we can say that the government should be responsible to the people. Because who elects the people, who elects the members in the Lok Sabha? People directly. This is parliamentary democracy. All political parties are represented in the government. Rahul Gandhi is not a minister. The government is responsible to the parliament and can be removed by it. My lord, government is not responsible to parliament. Government is responsible only to the Lok Sabha. If that is an option, you have to tick that option. If not, then let's look at the third option. The government is elected by the people and can be removed by them. Okay. The government is chosen by parliament but cannot be removed by it before completion of the fixed term. Haven't we seen the government falling? Mr. Vajpayee was once the Prime Minister for 13 days. So even before you complete your term, you can be removed by introducing and passing a no confidence motion. Now you may be confused between the two. The government is responsible to the parliament and can be removed by it. The government is elected by the people and can be removed by them. Parliamentary democracy would mean B is the most suitable answer. Because the government is responsible to parliament, legislature is parliament and can be removed by it. How can it be removed? Through no confidence motion. If the confidence motion fails, so B becomes the right answer. In the context of India, which one of the following is the characteristic appropriate for bureaucracy? Bureaucracy, we call them permanent executive. There is a political executive, for example, the ministers. There is a permanent executive, for example, is something that you aspire for to become part of the bureaucracy, civil services. And there are some important traits that a bureaucrat must have. What are these traits? You should be anonymous, not something that toppers these days do. Hire a social media manager, create and publish reels on social media to say that we are visible part of the government. You have to be anonymous. You have to be non-partisan. Even if tomorrow there is a Congress government, you have to help the ministers implement the policies the way you were doing when BJP was in power. So it doesn't matter. You have to be anonymous. You have to be non-partisan. But what is the characteristic which is appropriate for bureaucracy? An agency for widening the scope of parliamentary democracy. Does that mean in a presidential democracy we don't need bureaucracy? We need bureaucracy there as well to implement the laws. An agency for strengthening the structure of federalism. In fact, in bureaucracy, we have all India services as well. And we say all India services goes against the principle of federalism. Because these are the people, for example, IAS officers, IPS officers, Indian Forest Service officers. They're appointed by the union, trained by the union, can be removed by the union, dismissed by the union. But where do they serve? They serve in the states. That is why there have been various movements in India's independent history where some have called that we should be given the power to come out of all India services. For example, Anandpur Sahib resolution and various other resolutions were passed by various political parties saying we don't want to be part of the all India services because you weaken federalism through this. Political agency for facilitating stability and economic growth. Facilitating stability and economic growth, but economic growth would be too restrictive for bureaucracy because you are there for social security schemes as well, not just for economic growth. Agency for implementation of public policy. Now, when you say public policy, you make it broad-based. It's about economic policy. It's about social policy. It's about land reforms. It's about everything. That is the characteristic which is appropriate for bureaucracy. D is the right answer. Right? Great. Now let's look at another theme, the second theme, fundamental rights, directive principles, fundamental duties. All the questions asked by UPSC from these areas we will discuss now. And if you are yet to like the session, let me check. There are still a lot of people who have not liked the session. So press the like button and then I will start. Otherwise, I will end the session now. Which one of the following statements is correct? Rights. Rights can be broadly categorized into constitutional rights, statutory rights. Those rights which are provided by the Constitution are constitutional rights. Those rights which are provided by the law passed by the Parliament, those are statutory rights. But within constitutional rights, there can be fundamental rights and other constitutional rights. Fundamental rights are those rights which are mentioned under Part 3 of the Constitution. Other constitutional rights are mentioned in other parts of the Constitution, not necessarily in Part 3. For example, other constitutional right means a right to property as provided under Article 300 capital A. Right to vote provided under Article 326. But fundamental rights are the 6 set of rights provided under Part 3. Right to equality, right to freedom, cultural and educational rights, right against exploitation, right to freedom of religion, right to constitutional remedy. But this much you would be knowing, but sir, what exactly is a right? A right is something that you can claim from the state. For example, Professor Hannah Arendt. She has given the most beautiful definition of citizenship. She says, citizenship means right to have the rights. Once you have been given citizenship, then you can claim other rights from the state. For example, fundamental rights. Throughout the chapter on fundamental rights, you will come across a term called state. The state shall not deny equality. The state shall not discriminate. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this. The state shall not do that. That means you can claim your fundamental rights because the protector of your fundamental rights, the guardian of your fundamental rights is Supreme Court. If the state has violated your fundamental rights, you can drag the state to the court by filing a petition under Article 32 of the Constitution. So what are these rights basically? Rights are something that you can claim from the state. Rights are claims of the state against citizens? No. State can claim duties from you. Although it's not a claim, but state can request duty from a citizen. But the claim is by the citizen from the state. Right is not a privilege. Privilege is something that you are normally not entitled to, but you are still given. In a sense, you privilege some and not others. For example, if you're working in an organization and you are, let's say, at a senior level position. Let's say you are a senior vice president of an organization, or you are the chief operating officer of an organization. Whenever you travel, you have a privilege that you can travel business class. So that's a privilege for you. But for other employees, you have to travel economy class, or you have to travel by train, or you have to travel by road. You privilege some against the other. So you prioritize some as against the other. But rights are for everybody. Every citizen. So it's not a privilege of some. It's the claim of the entire set of people against the state. Rights are claims of the citizens against the state. This seems to be the right answer. Rights are privileges of a few citizens against many. It is not a privilege, it's a claim. So C is the right answer. Right? Great. This question was asked in Prelims 2017. Which one of the following are regarded as the main features of rule of law? Now, what is rule of law basically? If you ask a constitutional expert, he or she will tell you that rule of law is basically the second corollary Article 14 of the Constitution says, the state shall not deny equality before law and equal protection of the laws. What is this equality before law? If you ask a constitutional expert, he or she will say equality before law is nothing but the second corollary of A.V. Dicey's concept of rule of law. Corollary means when you read a particular statement, what is the next inference that you can draw from the statement? So when you look at equality before law, it is basically the corollary of the rule of law. And what is rule of law? Nobody shall be punished in body or goods except for a breach of law. So unless and until you have violated a law, you have committed a crime, you should not be arrested. Your liberty should not be snatched. Your property should not be confiscated. Anybody can sue or be sued. You can file a case against me. I can file a case against you. Do we have a system in India where only Brahmins can file a case and not Dalits? Or only Muslims can file a case and not Hindus? That's not the case. There is equality before law. That means anybody can sue or be sued. Equality before law is under Article 14. Article 14 is basically a fundamental right. Fundamental rights are basically what? Civil rights. And fundamental rights are basically limitations on the powers of the state. Remember the discussion? Constitutionalism. The government should and can be limited in their powers, and that their legitimacy depends upon whether it is observing those limitations, in the words of John Locke. So which one of the following are regarded as the main feature of rule of law? Is rule of law limitation of power? Yes, because it is a fundamental right. Does it mean equality before law? Yes. Does it mean liberty and civil rights? Yes. Because fundamental rights are those rights to ensure political democracy. But does that mean rule of law means people's responsibility to the government? No. We are not responsible to the government. We can claim rights from the state. So 1, 2, 4, C is the right answer. Great. One of the implications of equality in a society is the absence of, for example, when we look at equality before law. In simple terms, equality before law means three things. Number one, absence of privileges. No matter who you are, there are no privileges for you. That's what equality means. Equal subjection of all laws. And nobody is above the law. That's what we call equality before law. And one of the implications of equality in the society is the absence of privilege. Because there are no privileges. When there are no privileges, that means everybody is treated equally in the eyes of the law. Does that mean equality means absence of restraints? Absence of competition? Absence of ideology? When people are treated equally, that promotes competition. You may have your own ideology, and I will not discriminate against you because of what your political ideology is, or your social ideology is, or your economic ideology is. There will be still restraint on you. For example, the fundamental rights that we have, these are not absolute. They come under reasonable restrictions. So one of the implications of equality in the society is the absence of privileges. Let's look at question number 20. A legislation which confers on the executive or any administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles of the Constitution? Article 14 is the answer to this question, because Article 14 talks about equality before law. And equality before law also includes another fundamental right. There is another aspect to equality before law, and that is right against arbitrariness. If you give me uncontrolled, unguided discretion, what I will do, I will say whoever joined this class at 9 o'clock, I am going to teach them separately. Whoever joined this class at 8 o'clock, I am going to remove them from the live lecture. What am I doing? I am doing something which is arbitrary, which doesn't make any sense, which is without any logical understanding. Instead, if I would have said, Those who are engineers, poor engineering graduates, I will give them extra time because they will not be in a position to understand what I'm saying. But if you are from a legal background, law background, I will only allow you to ask me a single question. Why? Because you already know a lot. Maybe you just need a clarification. But if you are an engineering graduate, you will have the right to ask me 10 questions. So I am discriminating amongst the students. But this is not an irrational discrimination. This is not an arbitrary discrimination. This is based on some sound logic. So when you give executive uncontrolled power, unguided power, they can use their discretion. Discretion means they can do that without any check on their own. They will be in a position to make some arbitrary decisions which would violate Article 14, because Article 14 includes right against arbitrariness as well. Which one of the following factors constitutes the best safeguard of liberty in a liberal democracy? So you have liberty, you have the freedom, you have liberty of thought, liberty of belief, liberty of expression. How do we protect this liberty in a liberal democracy? There is an illiberal democracy, or for that matter, an authoritarian state, where you are not allowed to say anything, where you don't have the freedom of speech and expression, where you don't have the liberty. For example, something which was beautifully conceptualized in this novel 1984, written by George Orwell. That is why sometimes you may have come across a term in the newspapers. This looks like an Orwellian state, a massive surveillance state, where even thinking about something is a crime, thought crime. So in a liberal democracy, what is the best safeguard for liberty? Is it centralization of powers? Because if the powers are centralized in the government, then government can do anything. Is it committed judiciary? Now listen to me carefully. This is where you may be confused. Committed judiciary means judges should be committed to their role, to their responsibility, to their duties. Should not be like the Delhi High Court judge, where a huge pile of cash was unearthed when there was a fire, and now they dispute, saying, no, in the fire we did not unearth the cash, and the transfer to Allahabad High Court has got nothing to do with this bribe. But be that as it may, whatever, that's not committed judiciary. Committed judiciary is something, the slogan that was given by Indira Gandhi when she was the Prime Minister. I need committed bureaucracy, I need committed judiciary. That means the judges should be committed to the ideology of the ruling political party. Because during her time, when she tried to pass some progressive laws, for example, bank nationalization, for example, abolition of privy purse, these were struck down by the court, saying you are violating the right to property, you are violating right to equality. This is where Indira Gandhi said we need committed judiciary. Judiciary should be committed to the ideology of the ruling political party, which means they should be in favor of socialism. That's what committed judiciary is. So if the judiciary is committed to the ruling political party, and the ruling political party is violating your liberty, can this judiciary be your safeguard? No. Elected government, and the danger of threat to your liberty comes from government, whether it is elected or unelected. Even the elected governments can be a biggest threat to the liberty of the people. Elected governments do imprison the dissidents, do imprison those who criticize them. So the best safeguard would be separation of powers. That means power should be separated between legislature, executive, and judiciary. And judiciary has to be an independent institution. And if the executive violates your liberty, you can go to the court and say, my lord, the state has violated my liberty, and the courts will protect your liberty if the courts are indeed independent. So separation of powers is the best safeguard for liberty in a liberal democracy. Okay, great. In essence, what does due process of law mean? This has been one of the most highly debated, dissected question in the history of UPSC Civil Services examination. And in fact, this is a question where most of the teachers also got it wrong. Although they said that due process of law would primarily mean fair application of law, but that is not correct. The correct answer is the principle of natural justice. And this is something that I've explained numerous times in the past in my classes as well, in one YouTube session as well, where I discussed the most difficult questions asked by UPSC, and this was one of them. Now, let me explain it again briefly. Article 21 of the Constitution talks about the state shall not deprive an individual of his right to life and personal liberty, except according to the procedure established by law. Which later on Supreme Court in 1978 said means due process of law. And Supreme Court further said that what we follow principles of the natural justice. The question is saying, what does due process of law mean? Does it mean the procedure established by law? Clearly no, because these are different terms. Does it mean equality before law? No, equality before law is under Article 21, and here we are talking about Article 21. Equality before law is under Article 14. Here we are talking about Article 21. So now the confusion can be between A and C, whether it is principle of natural justice or the fair application of law. For that, you need to understand what is procedure established by law. If we follow procedure established by law, what will happen? I'm taking a class right now. Suddenly there is a knock at my door and the police, they're arresting me. Now you will approach the court. You will file a petition of habeas corpus. My lord, please release our polity teacher. Kill him, imprison him, but first let him cover the PYQ marathon. And then there is a one very much demanded lecture, Bear Act 3. Please allow him to finish the PYQ marathon and the Bear Act 3. After that, kill him. But right now, please release him. When the court will hear this petition, what will the court do? Court will have to see whether procedure established by law has been followed or not. If it has been followed, my right to life can be violated. Because right to life is not absolute. It can be limited. Exception is procedure established by law. The court will perform 3 tests. Number 1, is there a law, police, is there a law which justifies your arrest? Why are you arresting him? Sir, because he was teaching polity on YouTube. Is that a crime? Yes, sir. Legislature has passed a law saying teaching polity on Unacademy platform is a crime. If there is a law, okay, very good. Second, is this law valid? Valid in the sense there are 2 things related to validity. For example, the court would say, or the police will say, sir, we have arrested him under Section 66 capital A of the Information Technology Act, which says whoever uses an electronic device to transmit messages which causes annoyance to the public. For example, I referred to Rahul Gandhi, I referred to Mr. Modi and Amit Shah. Maybe it caused annoyance to the supporters of the Congress and the BJP. They filed a case before the police under Section 66 capital A. That's how I got arrested. Matter went to the court. Supreme Court says, is there a law? Yes, there is a law. Information Technology Act. Under what section? Section 66 capital A. But that is not a valid law. Because in 2015, in the Shreya Singhal case, we have said that Section 66A violates freedom of speech and expression. As such, it is unconstitutional. So you have arrested him under an invalid law. Set him free. But if the police says we have arrested, and there is second meaning of valid law. For example, the police says from this teacher, we have unearthed illicit money, or for that matter, counterfeit currency. Who passed that law against counterfeit currency? Karnataka Legislative Assembly. You will go to the court and say, my lord, release our polity teacher. Why? Because we have studied polity from him. Because according to him, only Parliament has the power to make a law and currency. Since Karnataka legislature has passed a law, Karnataka legislature is not competent to pass a law on this subject, because that is beyond the legislative competence of the Karnataka Legislative Assembly. Because on currency, only the Parliament has the power to make a law. So although there is a law, but the law is not valid, I will be set free. Third, whether the procedures mentioned in the law are followed or not. Procedure in the sense, I should have been produced before the magistrate within 24 hours. I should have been informed of the grounds of my arrest, that too in written format. You can't orally communicate and say, because you were teaching polity on Unacademy, that's why you are arrested. You have to tell me in written so that tomorrow I can challenge it before the court. This is procedure established by law. And if the court is satisfied that yes, there is a law which justifies my arrest, the law is valid as well, procedures also have been followed, you will be arrested. You will remain in custody. This is not an illegal arrest. But the first example that I told you, what if legislature had passed a law saying teaching polity on Unacademy is a crime? Is this a good law or a bad law or a preposterous, horrible law? It's a bad law, but the courts cannot help you. Courts under procedure established by law cannot help you if the legislature has passed a bad law. Courts cannot help you if the procedures that are followed in that law are irrational, unreasonable, unjustified. But in United States, we follow due process of law, where the court, apart from these three tests, will perform test number 4 as well. Is this law fair? Are these procedures reasonable, just? That means in due process of law, you are protected not only against executive, but also against the legislature, against the arbitrary actions of the legislature. And Supreme Court has said we follow principles of the natural justice as well, which means nobody shall be sentenced without being heard. You have to hear me, then you can punish me. Nobody shall be the judge in his own case. And the authority shall act bona fide, which means in good faith. Which authority? When executive is making rules, the intention of the executive has to be genuine, bona fide, good faith. When the legislature is making a law, it has to be in good faith. You can't deliberately target a community or a class or a tribe. Your intentions have to be great, bona fide. That means even if when we follow procedure established by law, it means fair application of law. What if procedure is not followed? Will you not be set free? What if I was not given the copy of my arrest? The grounds were not communicated to me. The court will set me free. That means procedure established by law within itself encompasses fair application of law. But whether the law is bad, reasonable, just, unjust, unreasonable, that is done only in the due process of law, and there we follow principles of the natural justice. So in essence, what does due process of law means? The principles of natural justice. A is the right answer. Got it? Any questions as of now? Great. What is the position of the right to property in India? Right to property till the 44th Constitutional Amendment Act 1978 was a fundamental right. But this was a fundamental right under Article 19(1)(f). And you know, all the articles under 19 are exclusively available to citizens. Fundamental rights are available to citizens as well as foreigners. But there are some fundamental rights which are exclusively available to the citizens. Which are those fundamental rights which are exclusively available to citizens? Articles 15, 16, 19, 29 and 30. But then because of 44th Constitutional Amendment Act, it was removed as a fundamental right. It became a constitutional right. Constitutional right under Article 300 capital A. Now, what is the position of right to property in India? Neither fundamental nor legal right. This is incorrect because it is a legal right. Sir, what is a legal right? Now, listen to me carefully. The supreme law of the Constitution. Can we say freedom of speech and expression is a legal right? Yes, it is a right provided by the law, the supreme law of land, Constitution, that too under Part 3, fundamental. So does that mean all fundamental rights are legal rights? Yes. All constitutional rights are legal rights? Yes. All statutory rights are legal rights? Yes. Does that mean all legal rights are fundamental rights? No. Only those legal rights which are mentioned under Part 3, they are fundamental rights. Does that mean all legal rights are constitutional rights? No, only those rights which are provided by the Constitution. Those are constitutional rights. So neither fundamental right nor legal right, this is incorrect because it is not a fundamental right, but it is a legal right provided by the Constitution under Article 300 capital A. So it's a constitutional right, legal right. Fundamental right available to citizens only. This is not the answer because it was prior to 44th Amendment. Legal right available to citizens only? No, because when it was a fundamental right, it was available only to the citizens. Now that it is other constitutional right, only these fundamental rights are available exclusively to citizens. Otherwise, rights are available to foreigners as well, aliens as well. So it is a legal right available to any person. That is the status of right to property. That is how companies acquire land in India, property in India, foreign companies as well. Legal right available to any person. B is the right answer. Right to privacy is protected under which of the article of the Indian Constitution? This question has been asked multiple times. And the answer is 21. This is according to the K.S. Puttaswamy judgment delivered by the Supreme Court in 2017 by the majority of 9:0. All the 9 judges who were part of this bench said right to privacy is a fundamental right under Article 21. Now, right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? Right to life and personal liberty is under Article 21 of the Constitution. Article 21 is part of Part 3 of the Constitution because Part 3 deals with fundamental rights. So Article 14 and the provisions under 42nd Amendment, no, it is under Article 21. Article 17 and direct Article 17 talks about abolition of untouchability. Article 24 and 44th Amendment, Article 24 talks about prohibition of child labor. Article 21 and the freedoms guaranteed under Part 3 of the Constitution, C is the right answer. Right? Very good. Which article of the Constitution of India safeguards one's right to marry the person of one's choice? Article 21 of the Constitution. And this question was asked when there was a case, Shafeen Jahan, where a Hindu lady, her name was Akhila, later on she converted into Islam and took the name of Hadia. And then she married this boy, Shafeen Jahan. The father of Miss Akhila or Hadia approached the court, Kerala High Court, and Kerala High Court annulled the marriage. despite the fact that this lady was an adult, had crossed the age of 18. When the matter reached the Supreme Court said Kerala High Court was wrong in annulling this marriage because right to marriage is a fundamental right under Article 21 of the Constitution. However, if this question is asked again today, the Supreme Court has now clarified that right to marry is not a fundamental right anymore. Why? Because of Suprio v. Union of India. (2024). Because in 2018, when Supreme Court in Navte Johar decriminalized homosexuality, where Section 377 will no longer decriminalize homosexuality. Homosexuality is no longer a crime. So right to love for LGBTQIA plus category was recognized. But they still were struggling for right to marry the person of their choice. This matter went to the court in Suprio versus Union of India. Supreme Court was told, please recognize right to marry as well for the LGBTQ community, just like you have recognized right to love for this community. Supreme Court said right to marry is not a fundamental right. But it was a fundamental right when this question was asked. Now it is no longer a fundamental right. Which one of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? This is where a lot of students have made mistakes. So when you look at untouchability, you feel that it is some form of an exploitation, and as such, it may come under right against exploitation. But protection against untouchability means Article 17. Article 17 says untouchability is abolished because this term is in quotes, because Constitution does not define untouchability. Constitution refers to untouchability in quotes. That means we are referring to the historic practice of untouchability as practiced since the later Vedic period. So this is not the untouchability in the literal sense or the English meaning of this term untouchability. That untouchability is abolished and its practice in any form is forbidden. Article 17, you would know, comes under Article 14 to Article 18 because it is this group which talks about right to equality. Because Article 14 to 18, right to equality. 19 to 22, right to freedom. 23 and 24, right against exploitation. 25 to 28, right to religious freedom. 29 and 30, cultural and educational rights. 32, right to constitutional remedy. So it comes under D, right to equality. Which of the following are envisaged by the right against exploitation in the Constitution of India? Right against exploitation means Article 23 and Article 24. Article 23 talks about prohibition of traffic in human beings because Article 23 prohibits 3 forms of discrimination, exploitation: traffic, begar, and other forms of forced labor. And Article 24 talks about prohibition of the employment of children in hazardous industries. And who are these children? Those who are less than the age of 14 years. Abolition of untouchability is under Article 17. It's under right to equality. Protection of the interest of minorities is under Article 29 and Article 30. So 1 and 4, C is the right answer. Right? Which part of the Constitution of India declares the ideal of a welfare state? When we look at directive principles of the state policy, under Part 4 of the Constitution, Article 37 talks about 2 important characteristics of directive principles. 1, governance of the country. Buffering happening? Is it fine now? Is it fine? Fine, fine. Great. So Article 37 of the Constitution, it talks about two important characteristics of directive principles. Number one, these principles are not enforceable in a court of law. That means, unlike fundamental rights, you can't go to the court and claim before the court, my lord, the state is not implementing these DPSPs. But Article 37 further says, nevertheless, these duties, these principles are fundamental for the governance of the country, and it shall be the duty of the state to implement them. Because the purpose of implementing directive principles is to implement socio-economic democracy in India. For socio-economic democracy, we have directive principles. For political democracy, we have fundamental rights. Because what is the purpose of directive principle? It is to ensure the creation of a welfare state. So which part of the Constitution of India declares the ideal of a welfare state? It is the DPSP, Directive Principles of the State Policy. A is the right answer. According to Constitution of India, which of the following are fundamental for the governance of the country? Read the question carefully. According to the Constitution, not according to you. According to you, anything can be fundamental for the governance of the country. According to the Constitution. And according to the Constitution means Article 37. Nevertheless, these principles are fundamental for the governance of the country. And the answer is C, Directive Principles of the State Policy. Under the Indian Constitution, concentration of wealth violates what? One directive principle is Article 39, Clause C. Another directive principle is Article 39, Clause B. These two directive principles are very important because these are the only two directive principles which have superiority, which have primacy over two fundamental rights, Article 14 and 19. And this has been something which is mentioned in Article 31, capital C of the Constitution. What is 39B? The material resources of a community. Shall be so distributed so as to subserve the common good. And this was the provision which was in news in the Bombay Private Property Association case, where the Supreme Court said not all private property is the material resource of a community, where a previous Justice Krishna Iyer doctrine was negated by the Supreme Court last year. So that is why 39B becomes important. 39B means the material resources of a community shall be so distributed so as to subserve the common good. And 39 Clause C says the operation of the economic system, no matter what economic system you use, should not result in the concentration of wealth to a common detriment, should not result in the concentration of wealth in fewer hands. So according to the Indian Constitution, concentration of wealth violates directive principles of the state policy. And what are these directive principles of the state policy? Look at this phrase and you will get the answer. What are those principles which direct the state when the state is enacting laws, when the state is making policies, programs? That's what we call directive principle. So these directive principles are basically positive obligations on the state. Whereas fundamental rights, these are negative obligations on the state. Sir, what is this positive and negative obligation? All the fundamental rights, when you read them, the state shall not deny equality. The state shall not deprive an individual of his right to life and personal liberty. The state shall not discriminate. The state shall not do this. The state shall not do that. That means what are these fundamental rights? Limitations on the powers of the state. Negative obligations on the powers of the state. Don't interfere. Don't deprive an individual of his liberty. Don't interfere with the liberty and dignity of an individual. But what are directive principles? In fundamental rights, we are asking the state, don't interfere. Stay away. Don't come closer. Stay away. Don't interfere with the liberty of an individual. But in directive principles, we are asking the state, please interfere. Please interfere so that you can enhance the standard of living of the people. Please interfere so that you can establish village panchayats and empower them with powers so as to enable them to function as units of rural, local self-government. Please interfere so that you can provide for equal pay for equal work. Please interfere so that you can prevent the concentration of wealth. Please interfere so that you can distribute the material resources of a community. Please interfere so that you can provide maternity benefit relief. Please interfere so that you can enact a uniform civil code. Please interfere so that you can separate executive from judiciary. Please interfere so that you can do this, you can do that. Please interfere so that you can establish a welfare state. That's the directive principle. And for that, Prelims 2020 question with reference to the provisions contained in Part 4. Part 4 means directive principles of the state policy. They shall be enforceable by courts? No. They shall not be enforceable by any court. The principles laid down in this part are to influence the making of laws by the state. 2 and 3. D is the right answer. Because what are these directive principles of the state policy? What are those principles which direct the state when the state is making laws, when the state is enacting laws, making policies? So 2 and 3 is the right answer. Consider the following statement regarding directive principles. These principles spell out socio-economic democracy in the country, right? For political democracy, we have fundamental rights. For socio-economic democracy, we have directive principles. The provisions contained in these principles are not enforceable by any court because these are not enforceable in the court of law, according to Article 37. So which of these statements are correct? Both the statements are correct. 1 and 2 is the right answer. Are these easy questions? Yes, no, maybe. Wake up, guys. Okay. In the Constitution of India, promotion of international peace and security is included in Article 51 of the Constitution. Directive principles of the state policy. Economic justice as one of the objectives of the Indian Constitution has been provided in, look at Preamble. Preamble talks about justice, social, economic and political. So economic justice is part of the Preamble as well. But socio-economic democracy is there in directive principles. When you establish a welfare state, your primary objective is to implement economic justice. So economic justice as one of the objectives of the Indian Constitution has been provided in Preamble and fundamental rights? No. Preamble and directive principles? Yes. Fundamental rights and directive principles? No. No. Preamble and DPSPs? B is the right answer. This question was asked in Prelims 2012. And I told you that we will not only be discussing questions asked from 2013 onwards, but some important questions from 2011, 2012 as well. Why? Because although Constitution does not talk about it, but constitutional experts have done this. What they have done, they have looked at all the DPSPs from Article 38 to 51. And they have classified them, categorized them. Some are reflecting the idea of socialism. These are socialistic principles. Some represent the ideology of Mahatma Gandhi. Those are Gandhian principles. And some are liberal intellectual principles. Although even this was once asked in the prelims examination, that Constitution classifies directive principles into Gandhian, socialist and liberal intellectual. That's not the case because Constitution does not categorize or classify DPSPs. But as civil services aspirants, you should know which of these directive principles are socialistic in principle, which are liberal intellectual, which are socialistic in nature. For that, you don't have to remember and memorize all these DPSPs. You just have to understand the concept. If you are aware of the ideology of Mahatma Gandhi, if you're aware of the ideology of the Karl Marx, then it becomes easy for you to identify which of these directive principles reflect Gandhism or socialistic principles or liberal intellectual principles. So consider the following provisions under the directive principles as enshrined in the Constitution of India. Which of the above are Gandhian principles that are reflected in DPSPs? Securing for citizens a uniform civil code, that's a liberal intellectual principle. Organizing village panchayats, yes, is a Gandhian principle because Mahatma Gandhi believed that India lives in the villages. He wanted villages to become self-sufficient. Promoting cottage industries in the rural areas, this is also a Gandhian principle. Securing for all workers reasonable leisure and cultural opportunities, this can be a socialistic principle. So 2 and 3, B is the right answer. Right? Consider the following statements. The Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights, and democracy. The Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. Again, a difficult question in the sense that a large number of teachers also got it wrong. But my students got it correct. Thankfully, touch wood. Does Constitution define basic structure? No. Because basic structure is a judicial innovation. Propounded by the Supreme Court in the Keshavananda Bharati case of 1973, where Supreme Court said, yes, Parliament has the power to use Article 368 to amend any provision of the Constitution, but save basic structure. So does the Constitution of India define its basic structure? No. This is a judicial innovation. So statement 1 is incorrect. The Constitution of India provides for judicial review. This term judicial review is not mentioned in the Constitution. Now, you will never see concept like judicial review mentioned anywhere in any part, any article, any schedule of the Constitution, any provision of the Constitution. Judicial review is not mentioned. But we can trace this concept of judicial review to Article 13, to Article 32, to Article 226 as well. Article 13, for example, it says there are 4 clauses under Article 13. Clause number 1 says, if Constitution got enacted on 26 January 1950, but there may have been laws which were in operation prior to the commencement of the Constitution. What will happen to those laws? Will those laws continue after the enactment of the Constitution, or will those laws stop at the time of the enactment of the Constitution? Article 13, Clause 1 says those laws will continue as long as they are in agreement with fundamental rights. And if they are not in agreement with fundamental rights, they shall be declared null and therefore void. Now the implication is, who can declare it null and void? It can't be the executive because executive has to implement those laws. It can't be legislature because legislature primarily has to enact laws. So it has to be a third organ because we have separation of powers. Third organ is the judiciary. So judiciary has the power, implicit power of judicial review. Further, Article 13, Clause 2 says, the state shall not enact any law to delete a fundamental right, abridge a fundamental right. And if it is passed, that law shall be declared null and therefore void. Now, assumption is, who will enact that law? Legislature. And if legislature has enacted a law to delete fundamental right, will the same legislature say, no, this law is void? No. Because then it will be you are judging your own case. You are judge in your own case. You are violating the principles of the natural justice. Can it be executive? Because executive and legislature, they are closely linked together in India, in India's parliamentary system. Because we derive executive from the legislature. There is no strict separation of powers between executive and legislature in the system in India, in the constitutional scheme in India. Now, which is the third organ which is left? That's judiciary. So we can trace the concept of judicial review to Article 13. Or if your fundamental rights are violated, go to the court. Supreme Court under Article 32, go to the High Court under Article 226. But does Constitution of India provide for judicial review? The answer is no. D, neither 1 nor 2 is the right answer. Right? Any questions as of now? Perfect. Consider the following statements. A bill amending the Constitution requires a prior recommendation of the President. Now, this is a constitutional amendment bill. This constitutional amendment bill can be introduced in either Lok Sabha or Rajya Sabha, can be introduced in either of the two houses. Who can introduce it? Can be a government minister, can be a private member as well. Now, who is a private member? A member of the parliament who is not a minister is a private member. So this constitutional amendment bill can be introduced in either of the two houses of the parliament by either a government minister or a private member. It does not need the prior approval of the president. And in both the houses of Indian parliament, it requires special majority. Which type of special majority? Special majority flavor 2. What is that special majority flavor 2? Majority of not less than 2/3 of the members present and voting, and majority of the total membership of the house. And if this bill tries to amend the federal features as well, it needs ratification by at least half of the state as well, half of the state legislatures as well. But if one house passes this bill, other house rejects this bill, the bill is dead, because there is no concept of the joint sitting of the two houses in case there is a deadlock or a constitutional amendment bill. But once it is passed by both houses of the parliament, it is sent to president. What is the option? What are the alternatives available with the president? Just one. You have to sign it. And that is provided by the 24th Constitutional Amendment Act of 1971. Because previously it was not binding on the president to sign it. He could have signed it, he could have withheld his assent, he could have sent the bill back, but 24th Constitutional Amendment Act made it mandatory on the president to give assent to a constitutional amendment bill. Let's now look at the question. A bill amending the Constitution requires a prior recommendation of the President of India? No. When a Constitution amendment bill is presented to the President, it is obligatory for the President of India to give his or her assent. Correct. A Constitution amendment bill must be passed by both the houses of the Parliament by a special majority, and there is no provision for joint sitting. 2 and 3B is the right answer. Right? Great. An amendment to the Constitution of India can be initiated by an introduction of the bill in the Lok Sabha only. No. I told you previously, in either of the two houses. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by the legislature of all the states. No. Legislatures of at least half of the states. So which of the statements given above are correct? Neither 1 nor 2. D is the right answer. Which of the following statement is or are true of the fundamental duties of an Indian citizen? A legislative process has been provided to enforce these duties. Now, fundamental duties were not part of the Constitution. These fundamental duties are mentioned under Article 51 capital A. These are mentioned under Part 4, capital A. And there are 11 fundamental duties. These duties got added to the Constitution by the 42nd Constitutional Amendment Act 1976, based on the recommendations of the Sardar Swaran Singh Committee. Right or wrong? Right. When fundamental duties were added to the Constitution, this was the period of emergency. Indira Gandhi was asked, she was the Prime Minister, what is the need to provide a list of fundamental duties? She said, people are aware of their rights. I want to make them aware of their duties as well. And then first 10 and later in the year 2002, through another constitutional amendment, 86th Constitutional Amendment Act, 11th fundamental duty got added. So in total, we have 11 fundamental duties. But these fundamental duties are not legal duties. What does that mean? That means Constitution does not provide for a punishment in case you don't follow this fundamental duty. These fundamental duties are exclusively available to citizens. For example, abide by the Constitution, respect its ideal, national flag and the national anthem, to value and preserve the rich heritage of our composite culture, to safeguard public property and to abjure violence, to have compassion for living creatures, to develop scientific temper, humanism, spirit of inquiry and reform, to uphold unity, integrity, sovereignty of the India. All these are the fundamental duties, but what if you don't follow these fundamental duties? Nothing will happen to you because these are not legal duties. That means Constitution has not prescribed a punishment in case you violate these fundamental duties, you don't follow these fundamental duties. But sir, I have a question. What if I don't respect the national flag or the national anthem? I can also be arrested. So for not following a fundamental duty, I can be arrested. Yes, you can be arrested, but not because you are not abiding by the fundamental duty. You can be arrested because you are violating a law called Prevention of Insult to National Honor Act 1971. For violating that law, you can be arrested. Which means Constitution, although it does not prescribe a punishment in case you don't follow a fundamental duty, abide by a fundamental duty, but legislature can enact a law to make these fundamental duties legal duties. That's something that you have to keep in mind. So a legislative process has been provided to enforce these duties? No. They are correlative to legal duties. They are not legal duties. If these were legal duties, that means you had to abide by them. That means if you don't follow it, maybe we can go to the court and enforce it. Maybe the court can issue a writ of mandamus and force you to perform this duty because it's a legal duty. So which of the given code is correct? D, neither 1 nor 2 is the right answer. Right? Very good. In the context of India, which one of the following is the correct relationship between rights and duties? Rights are correlative with duties. And what does that mean? Let's park your thoughts. Wait. Rights are personal and hence independent of society and duties. Rights are personal or rights are provided by the Constitution? And these rights are also having reasonable restrictions in the interest of the society. Can't be the case. Rights, not duties, are important for the advancement of the personality of the citizen. Rights as well as duties may be important for advancing the personality of the citizen. For example, develop scientific temper, spirit of inquiry, reform. That's a fundamental duty. That is important for developing the personality of an individual. Duties, not rights, are important for the stability of the state. Rights are more important for the stability because if there are no rights, there is no liberty. There is chaos. Rights are correlative with duties. So it's like give and take. It's like mutualism. In the sense that state and citizens. Citizens have duties towards the state, and state ensures your rights, although these rights are provided by the Constitution, but you can claim these rights from the state. So they are correlative to each other. Rights which you can claim from the state, and state can impose duties. A is the right answer. Okay? Great. Under the Constitution of India, which one of the following is not a fundamental duty? And for fundamental duties, I have given you one acronym, which is SSP, ACU, DVD, PRW. These are the 11 fundamental duties. To strive towards excellence in all areas of human endeavor, to safeguard public property and to abjure violence, to promote the rich heritage of our composite culture, to abide by the Constitution, respect its ideals, national flag and the national anthem, to cherish and follow the noble ideals which shaped our struggle for freedom, to uphold the unity, integrity, sovereignty of India, to develop scientific temper, spirit of humanism, inquiry and reform, to value and preserve the rich heritage of our composite culture, to defend the country and render national service when called upon to do so, to promote a spirit of inquiry, to develop compassion for living creatures, and to renounce those practices which are derogatory to the dignity of the woman. And if you are a parent or a guardian, it shall be a fundamental duty on you to ensure that you provide educational opportunities to your children or your ward in the age group of 6 to 14. And it is this fundamental duty which got added by the 86th Constitutional Amendment Act 2002. This was the time when Article 21 capital A was added to the Constitution as a fundamental right. So to develop scientific temper, it is a fundamental duty. To safeguard public property, it is a fundamental duty. To abide by the Constitution and respect its ideals, it is a fundamental duty. What is not a fundamental duty is to vote in public elections. It is not a fundamental duty under Part 3 of the Constitution, according to the Constitution. So if it is according to you, yes, voting in public elections is a duty that all of us must perform. But according to the Constitution, it is not a fundamental duty. Another question from Prelims 2012. Which one of the following provisions of the Constitution of India have a bearing on education? Is it directive principle? Yes, because there is a directive principle. Prior to 2002 amendment, 86th amendment, the directive principle was, it was a directive to the state that you have to provide educational opportunities to all the kids in the age group of 6 to 14. Now, when that became a fundamental right, this directive principle was recast. Now the state has a directive principle to ensure early childhood care from 0 to 6 years. So directive principles have a bearing on education. Rural and urban local bodies, whether it is 11th schedule of the Constitution, which provide functional items for panchayats in rural areas, or the 12th schedule, which provide for functions to the urban local bodies. Education is under the control of the local governments. That is why we have schools by the panchayats. We have schools by the urban local bodies. 5th schedule and 6th schedule, these are primarily meant to do what? These are primarily meant for, let's say, 6th schedule is meant for the administration of tribal areas in states other than, in states of Assam, Meghalaya, Mizoram, and Tripura. And the Constitution envisages that these tribal areas in these 4 states, they are created as autonomous districts. When they are created as autonomous districts, that means they have the autonomy, they can pass laws, they can impose taxes, they can pass laws for the education as well. They can have education based on their own language or own script as well. Because the purpose of Schedule 6 is to protect the cultural identity of the tribals. Similarly, in Schedule 5 areas also, we need to ensure that these tribal areas, they are provided education. So governor has the additional responsibility there. 7th schedule talks about distribution of legislative subjects. Education was initially in the state list. Then it was transferred from the state list to the concurrent list. When? During emergency, because of the 42nd Constitutional Amendment Act. So all of them have the bearing on education. D is the right answer. Which of the following is or are among the fundamental duties of citizens laid down in the Indian Constitution? To preserve the rich heritage of our composite culture. If you can remember and memorize this, now it becomes easier. To protect the weaker sections of the society from social justice, that you have never heard from me. To develop the scientific temper and spirit of inquiry. To strive towards excellence in all areas of individual and collective activity. 1, 3, 4, C is the right answer. So now we have covered two big themes. Theme number 1 related to basics, related to Preamble, Union and its territories, citizenship. Then theme number 2, where we covered fundamental rights, directive principles, fundamental duties, amendment to the Constitution. Now what we will do, we will take a break. It is 10:05. We will come back at 10:20. We'll take a 15-minute break. And then we will resume and we will discuss executive and legislature. So we have covered 44 questions till now. There are still close to 80, 83, 84 questions more. And we will cover them in breaks of 2 hours. Today, spend the time with me. And I promise this is going to be extremely fruitful for you. See you in 15 minutes at 10:20. See you on the other side of the break. Shall we continue? Now, this is the most important aspect of this discussion because from this topic, executive and legislature, a large number of questions have been asked in the prelims examination during this period. Let's look at all these questions one by one. The main advantage of the parliamentary form of government, and I told you previously, whenever you come across this phrase, parliamentary form of government, you have to keep in mind that it means Council of Ministers are responsible to Lok Sabha, or which means the government is accountable to the legislature, or the government is accountable to the people. In a parliamentary form of government, executive and legislature work independently. That is a feature of a presidential form of government. Because, for example, the President of the United States, he is the part of the executive. Is he part of the legislature? No. So in a parliamentary democracy, executive and legislature, there is no strict separation of powers between them. It provides for continuity of policy and is more efficient. In a sense, we assume that the presidential form of government is more efficient because the decisions are taken quickly because the Council of Ministers are not accountable to the legislature. The executive remains responsible to the legislature, which means executive, which is the government, remains responsible and accountable to the legislature. And the head of the government cannot be changed without election. Even without election, the head of the government can be changed. For example, Mr. Kamal Nath was the Chief Minister of Madhya Pradesh, but then he resigned. And without election, Mr. Shivraj Singh Chauhan became the Chief Minister. So head of the government can be changed even without election. But here it is saying head of the government cannot be changed without election, which is not the case. So this is incorrect. So C is the right answer. Which one of the following constitutional amendment states that the total number of ministers, including the Prime Minister, in the Council of Ministers shall not exceed 15% of the total number of members of the House of the People? In original constitution, there was no limit. The number of ministers would be decided by the Prime Minister. But thanks to Mr. Vajpayee, when he was the Prime Minister, 91st Constitutional Amendment Act was passed and a limit was imposed that the strength, the composition of Council of Ministers, including the Prime Minister, shall not exceed 15% of the Lok Sabha. So that was the 91st Amendment. Consider the following statements. The Constitution of India classifies the ministers into 4 ranks. This is not true because Constitution only says the minister shall be appointed by the President on the advice of the Prime Minister. The ministers hold office during the pleasure of the President. But for that, we say all the executive powers are vested in the name of President. And how President will exercise these executive powers, for that rules shall be made. And these rules were made in 1961, called the Allocation of Business Rules. And it is these rules which talk about cabinet ministers, ministers of state with independent charge, minister of state, deputy minister, not the Constitution. The total number of ministers in the union government, including the Prime Minister, shall not exceed 15% of the total number of members in the Lok Sabha. This is correct. Which of the statements are correct? B, 2 only is the right answer. Now, this was the question asked in 2007. The Council of Ministers in the Union of India is collectively responsible both to Lok Sabha as well as Rajya Sabha. You know that parliamentary democracy would mean Council of Ministers are responsible only to Lok Sabha, to the House which is directly elected by the people, not to the Rajya Sabha. That is why the kind of motions that you see, no confidence motion, adjournment motion, censure motion, these can be introduced only in Lok Sabha, not in the Rajya Sabha. The members of both Lok Sabha and Rajya Sabha are eligible to become the ministers of the union government. For example, Dr. Subramanyam Jaishankar is the member of the parliament from Rajya Sabha, but he is the minister. So whether you are from Lok Sabha or Rajya Sabha doesn't matter, you are eligible to be appointed as a minister. In fact, even if you are not a member of Lok Sabha or Rajya Sabha, you can still be appointed by the president as the minister on the advice of the prime minister. But within 6 months, you have to get yourself elected, or you have to become a member of either Lok Sabha or Rajya Sabha. So assertion is false, but the reason is true. R is true. D is the right answer. The Prime Minister of India at the time of his appointment or her appointment, just like a minister, Prime Minister is also a minister. So as a minister, you can be either from Lok Sabha or Rajya Sabha, or you cannot be a member of either of the two houses, but you have to become a member of either house of the Indian Parliament within 6 months. Same applies to the Prime Minister as well. So the Prime Minister of India at the time of his or her appointment need not necessarily be a member of one of the houses of the Parliament, but must become a member of one of the houses within 6 months. A is the right answer. Right? Great. Need not necessarily be a member of one of the houses, but must become a member of the Lok Sabha within 6 months. If we are talking about the UK Prime Minister, UK Prime Minister has to be necessarily from the House of Commons. Cannot be from the House of Lords. But that's not the case with India. For example, Mr. Modi is from Lok Sabha, but previously Dr. Manmohan Singh, he represented the state of Assam in the Rajya Sabha for 10 years. Must be a member of one of the houses? No. Must be a member of the Lok Sabha? No. So A is the right answer. Out of the following statements, choose the one that brings out the principle underlying the cabinet form of government. And whether it is a cabinet form of government or a parliamentary form of government, both mean more or less the same. Cabinet form of government means cabinet ministers. They basically take all the decisions. It is the cabinet which meets regularly, headed by the Prime Minister. So what is the principle underlying cabinet form of government? An arrangement for minimizing the criticism against the government whose responsibilities are complex and hard to carry out to the satisfaction of all. Why should we minimize the criticism of the government? Isn't criticism of the government part of your freedom of speech and expression? Although it is not an absolute right, but that is your right. A mechanism for speeding up the activities of the government whose responsibilities are increasing day by day. If you want to speed up the decision-making policies of the government, for that the best form would be presidential form, because you are not accountable to the parliament. A device for strengthening the hands of the head of the government whose hold over the period is in a state of decline. Now, these are extreme statements. And whenever you come across these extreme statements, you should always assume that such statements are untrue, false. So a mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. Because parliamentary democracy would mean Council of Ministers are collectively responsible to the Lok Sabha, which means responsible to the public. C is the right answer. With reference to the election of the President of India, consider the following statements. Now, we know for the election of the President, we follow proportional representation system. And in proportional representation system, we assign value to the vote of an MLA based upon the population of that state. And the population figure that we take into account is that of 1971 census. Why? Because after that, the number of seats were frozen. After that, delimitation was frozen for 25 years. That is why 1971 becomes the basis, which primarily means that the value of vote of an MLA varies from state to state. The value of vote of an MLA of UP will be more than the value of vote of an MLA in Sikkim, because the population is the difference. So the value of vote of each MLA varies from state to state. This is correct. This is according to the population. The value of vote of MPs of Lok Sabha is more than the value of vote of MPs of Rajya Sabha. In fact, value of vote of an MP of Lok Sabha is equal to the value of vote of an MP of Rajya Sabha. So which of the statements are correct? A, one only is the right answer. For that, if you need the formula is, what is the value of vote of an MP? Value of vote of an MP is equal to total value of votes of all MLAs of states divided by total number of elected MPs. Because who is part of the electoral college to vote to elect the President of India? You have to be an elected member of both houses of the parliament. You also have to be the elected member of the state legislative assemblies. And state legislative assemblies include the union territory of Delhi and Puducherry. So not J&K, in my understanding, not J&K. Why? Because to make UT MLAs part of the electoral college, for that a constitutional amendment is required. And this constitutional amendment should be ratified by not less than half of the states as well. Because it is this mechanism which was followed when Delhi and Puducherry MLAs were made part of the electoral college. Because this amounts to amending the federal feature of the constitution. And I have told you previously, if the parliament wants to amend the federal feature of the constitution, you need to pass a constitutional amendment bill which needs to be ratified by at least half of the states. And one such federal feature is manner and method of the election of the President of India. So what is the right answer? A, one only is the right answer. This question was asked in Prelims 2023 with reference to the finance bill and money bill. This is where some of you may have made a mistake. And those who would have answered this correctly, UPSC would have deducted 0.67 marks. Those who have answered it incorrectly, maybe they would have got 2 marks extra. Why? Because finance bill and money bill, they are same. What is money bill? It's a finance bill. What is finance bill? It's a money bill. So it is not financial bill. But here in this question, you have to assume that the examiner is asking you financial bill and money bill. It is not finance bill. You have to assume that it is financial bill. Why? Because otherwise UPSC would not have asked finance bill and money bill. So you have to assume it is asking for financial bill and money bill. How? Just read the statements. When the Lok Sabha transmits finance bill to the Rajya Sabha, it can amend or reject the bill. Ideally, this statement is incorrect because finance bill is a money bill. But if it's a financial bill, when Lok Sabha transmits financial bill to Rajya Sabha, it can amend or reject this bill. This is correct. When the Lok Sabha transmits money bill to Rajya Sabha, it cannot amend or reject the bill. It can only make recommendations. This is also correct because here it's specifically asking for money bill. In the case of disagreement between the Lok Sabha and the Rajya Sabha, there is no joint sitting for money bill, which is correct because Rajya Sabha has an inferior role when it comes to money bill. Rajya Sabha cannot reject a money bill. Rajya Sabha cannot amend a money bill. Rajya Sabha can only make recommendations. And if Rajya Sabha does not act on this money bill for 14 days, at the end of the 14-day period, we can assume that both houses of the parliament has passed this money bill in the same form and shape as it was passed by the Lok Sabha. But a joint sitting becomes necessary for a financial bill. In case of a financial bill, there can be a joint sitting. In case there is a deadlock over a financial bill, Lok Sabha passes it, Rajya Sabha rejects it. To resolve this deadlock, there can be a joint sitting. But it depends upon the government. It depends upon the president. If the president wants to resolve this deadlock, he may notify a joint sitting. But it is not necessary. That is why statement 1 and 2 is correct. Only 2 statements are correct. B is the right answer, because here you have to assume that it is talking about financial bill under Article 117 and money bill under Article 110. Done. And in fact, this has been, luckily, I viewed it the same way when this question was asked in 2023. That video is available on the YouTube channel as well. Part of my previous organization where we discussed the previous years, we discussed the prelims 2023 analysis. I'd made the same point, and luckily once the answer key was released by the UPSC says only 2B is the right answer. Clear? Great. With reference to Deputy Speaker of the Lok Sabha, consider the following statements. As per the rules of procedure and conduct of business, the election of the Deputy Speaker shall be held on such date as the Speaker may specify. This is correct. There is a mandatory provision that the election of the candidate as Deputy Speaker of the Lok Sabha shall be from either principal opposition party or the ruling party. Constitution says under Article 93 that the House of the Lok Sabha shall, as soon as may be, elect 2 of its members, one as the Speaker and the other as the Deputy Speaker. It does not say that the Speaker has to be from the ruling party or the ruling coalition, or the Deputy Speaker has to be from the opposition. Although there is a convention, an unwritten rule, that the Speaker is from the ruling party or the ruling coalition and the Deputy Speaker is invariably from the opposition. The Deputy Speaker has the same power as of Speaker when presiding over the sitting, and no appeal lies against his rulings. This is also correct. The well-established parliamentary practice regarding the appointment of the Deputy Speaker is that the motion is moved by the Speaker and duly seconded by the Prime Minister. This is not correct. A, 1 and 3 is the right answer. Okay, great. Along with the budget, the Finance Minister also places other documents before the Parliament, which include the macroeconomic framework statement. The aforesaid document is presented because this is mandated by, previously along with the budget, economic survey also used to be presented. But now it is presented one day before the budget or a couple of days before the budget. And what about this macroeconomic framework statement? This has been mandated because of the FRBM Act, Fiscal Responsibility and the Budget Management Act, which was passed by the Parliament in 2003. So D is the right answer. With reference to Union budget, consider the following statements. The Union Finance Minister, on behalf of the Prime Minister, lays the annual financial statement before both the houses of the Parliament. Incorrect. Constitution does not refer to budget at all anywhere in its text. Constitution refers to budget as annual financial statement under Article 112. So the word budget is not there in the Constitution. But what is budget? Budget. It's basically appropriation bill and the finance bill. Expenditure side and the revenue side. Which means it's like a financial statement. And this annual financial statement is mentioned under Article 112. And Constitution says it shall be the responsibility of the President to lay down before both houses of the Parliament an annual financial statement. And that annual financial statement is laid down by the Union Finance Minister on behalf of the President, not on behalf of the Prime Minister. At the Union level, no demand for a grant can be made except on the recommendation of the President of India. This is a clear-cut constitutional provision, because what is grant basically? This is part of the appropriation bill where the concerned ministry is asking the Parliament, please give me money for the next financial year. And no demand for grant can be made except on the recommendation of the President. So which of the following statements are correct? B, 2 only is the right answer. Great. Very good. Consider the following statements. The Parliament Prevention of Disqualification Act 1959 exempts several posts from disqualification on the grounds of office of profit. What is this office of profit? Is not defined in the Constitution. And what is this office of profit? It is one small grain of separation of powers between executive and legislature. Because we are a parliamentary democracy. And in a parliamentary democracy, Constitution says that there shall be separation of powers between executive and judiciary. That is mentioned under Directive Principles of the State Policy. That is mentioned under Article 50 of the Constitution. But since we are a parliamentary democracy, executive is drawn from the legislature. But even then, there is one small separation of powers created called office of profit. Which means, what is the job of the legislature? Or what is the job of a legislator? The job of the legislator is to keep a check on the executive. But how can you keep a check on the executive if you are under the control of the executive? For example, you are occupying an office which is created by the executive, which is controlled by the executive. Because as a legislator, if you're occupying an office which is controlled by the executive or created by the executive, there will be a clash between your duty and your interest. Because your duty is to keep a check on the executive, but your interest is to keep the executive happy because you are occupying an office under the executive. That is why Constitution says if a legislator holds an office of profit, you will be disqualified. But for that, there are certain offices which are exempted. For example, Deputy Chairman of the Planning Commission. Can a legislator be appointed as the Deputy Chairperson of the Planning Commission, erstwhile Planning Commission, which was abolished in 2015 and then replaced with the Niti Aayog? Why? Because even if a legislator was appointed as the chairman of the Planning Commission, you would not be disqualified because it is this law which exempts certain offices from the office of profit. That means although this is an office under the executive, but if a legislator is occupying this office, you will not be disqualified because you are saved from disqualification. Same was the case when Srimati Sonia Gandhi was the member of parliament in Lok Sabha from Rai Bareli constituency. But she was also the chairperson of the National Advisory Council, which was viewed as an office of profit. Then she resigned. When she resigned, by the time Parliament had amended this law to exempt this post of NAC from the office of profit. That means, Madam Gandhi, once you are elected, we have already added this office in the exemption list. That means even if as a legislator, you are occupying this office, you will not be disqualified because it is kept under exemption list. So Parliament Prevention of Disqualification Act 1959, and this is famously known as the Office of Profit Act. It exempts several posts from disqualification on the grounds of office of profit. This is correct. For example, you can be a legislator and at the same time you can be the chairperson of the National Commission for Scheduled Castes, National Commission for Scheduled Tribes, National Commission for Women, because these posts are exempted. The above mentioned act was amended 5 times. Now, this is a tricky part. Whenever you come across such terms or such statements, you have to assume something. And you have to assume that even if I don't know the answer to the statement, but my knowledge of correct or incorrect will have no bearing on my ability to answer this question. Which means, even if you don't know the statement, you can still answer this question by looking at the remaining statements. What is the remaining statement? You know statement 1 is correct. The term office of profit is well defined in the Constitution. I have told you it is not defined in the Constitution at all. So you know 3 is incorrect. So 3 is there in 3 statements. So regardless of the fact that whether you know that this Office of Profit Act was amended 5 times or 10 times or 100 times, this is immaterial to your ability to answer this question, because by elimination method, you can mark it correct. A, 1 and 2 is the right answer. Right? Great. Consider the following statements. In the first Lok Sabha, the single largest party in the opposition was the Swatantra Party. Sir, how would we know? Again, even if you don't know this answer to the statement, you can still answer this question. In the Lok Sabha, leader of opposition was recognized for the first time in 1969. This is correct. Although the statutory status was given in 1977. But 1969, when there was a split in the Congress party, when Congress split into Congress I and Congress O, Congress Indira, Congress Organization, then leader of opposition was recognized by the speaker for the first time. In the Lok Sabha, if the party does not have the minimum of 75 members, its leaders cannot be recognized as the leader of the opposition. Although there is no such thing as minimum number. Constitutions, the rules say, leader of opposition, listen to me carefully, leader of opposition is to be recognized by the speaker. Speaker of the Lok Sabha, chairperson of the Rajya Sabha, because in Rajya Sabha also we have the leader of the opposition. But who is that leader of opposition going to be? The leader of single largest party. In opposition and recognized as such by the speaker. Sir, what are you saying? I am saying look at Delhi in 2015. 70 seats were up for grabs in this election. Aam Aadmi Party bagged 67 seats. BJP bagged 3 seats. Even then, one leader from the BJP was recognized by the speaker as the leader of the opposition. Why? Because there is no such thing as 1/10. Remember and listen to me carefully. There is no such thing as 1/10. It is a convention which has got developed. Because in the first Lok Sabha, seating arrangement was to be made. Seating arrangement in the sense, for example, there is a wedding at in your family. Now, there is a photo op. Who will be seated where? Those who are seated in the front row, they will occupy important positions in your family. So the Pupaji, the brother-in-law, will occupy the front post. Seating arrangement becomes important. If Pupaji is relegated to the later row, he will create a row and then will leave the wedding because you disrespected him by not giving him a prominent place in this photo op. So seating arrangement becomes important. So in the first Lok Sabha, when seating arrangement was to be decided, the speaker said, I will give prominent position seating to those political parties who have some numbers, some strength in the Lok Sabha. And if you have got 1/10 of the strength of the Lok Sabha, I will treat you as a party. I will give you prominent position seating arrangement. But if you have got less than 1/10 of the seats in the Lok Sabha, I will consider you as a group. And I may not give you a better seating arrangement in the Lok Sabha. And then somehow this 1/10 rule, which was meant for seating arrangement, became the rule, became the convention for recognizing leader of the opposition. Although this is not mentioned in the rule. But this rule has been followed consistently because in 2014 also, 2019 also, no political party got 1/10 of the seats. Now, Congress has got 99 of the seats, which means more than 1/10. Which means whoever gets more than 55 seats, the leader of that party will be recognized as the leader of the opposition by the speaker. And the speaker recognized Rahul Gandhi as the leader of the opposition because your political party has got more than 1/10 of the seats. So even if we take 1/10, it is 55, it is not 75. So 3 has to be incorrect. Which means what is the only option? B2 only is the right answer. Which means in the first Lok Sabha, it was not the Swatantra Party, it was the Communist Party of India, which was the single largest party. It had close to 16 seats. Done? Great. Question 58. With reference to the Parliament of India, which of the following parliamentary committees scrutinizes and reports to the House whether the powers to make regulations, rules, sub-rules, bylaws, etc. conferred by the Constitution or delegated by the Parliament are being properly exercised by the executives within the scope of such delegation? This is what we call delegated legislation. Or subordinate legislation. Sir, what does that mean? That means if we look at Parliament, It makes a broad law. For example, Parliament enacted Citizenship Amendment Act in 2019. It broadly said few things, that if you are from Pakistan, Afghanistan, Bangladesh, and you belong to the 6 religious minorities of these countries, whether you are Hindus, Christians, Buddhists, Sikhs, Jains, Parsis, and if you have entered India on or before December 31, 2014, you are eligible for citizenship, which means you are not treated as illegal migrants, because illegal migrants are not eligible for citizenship. This was the law enacted by the Parliament. But how do we know whether these people have come from Pakistan, Afghanistan, Bangladesh? Whether they have come on or before December 31, 2014? Whether they are indeed Hindus, Christians, Sikhs, Buddhists, Jains, Parsis? For that, rules are to be made. And these rules are made by the executive. Rules are made by the bureaucrats. These rules are what we call delegated legislation, because Parliament has delegated the rule-making power to the executive, to the bureaucrats. And that's how CAA rules got enacted in the year, passed in the year 2024. But what if these rules say, we will grant citizenship to Muslims as well? It will go against the parent law. Because parent law says you can give citizenship to only Hindus, Christians, Sikhs, Buddhists, Jains, Parsis. For that, there is a committee of the Parliament called Committee on Subordinate Legislation, which, when the rules are made by the executive, this committee of the Parliament will look at those rules and see whether these rules are in conformity with the parent act, whether these rules are in agreement with the law enacted by the Parliament. That is what we call Committee on Subordinate Legislation. Clear? Great. Consider the following statements. The Speaker of the Legislative Assembly shall vacate his or her office if she ceases to be the member of the Assembly. Now we have the Speaker of the Legislative Assembly. Once the elections are over, then in the first session of the new Legislative Assembly, the Speaker has to be elected, right? And you will remain in office as long as you are a member of the Legislative Assembly. Because who is eligible to become the Speaker of the Legislative Assembly? The member of the Legislative Assembly. Now, what if you are disqualified? What if you resign? In that case, you shall cease to be the Speaker as well. So the Speaker shall vacate his office if she ceases to be the member of the Assembly. This is correct. Whenever the Legislative Assembly is dissolved, the Speaker shall vacate his office immediately. Which of the statements are correct? A, one only is correct. Why? Because according to Constitution, this is not a rule, this is not a convention, this is according to Constitution. The Speaker does not resign when the Lok Sabha or Legislative Assembly is dissolved. For example, the normal term of the Lok Sabha or the Legislative Assembly is 5 years. Once 5-year term is over, Legislative Assembly is dissolved. But Speaker will not resign. Speaker will remain in office, remain in office, remain in office. Now, this is the first day of the newly constituted Legislative Assembly. That means now new Legislative Assembly MLAs have got elected. Now, this is their first day. The morning of this first day, the first session of the newly constituted Legislative Assembly, this is when the Speaker of the previous Assembly resigns. Where is it mentioned? Constitution. So, when the Legislative Assembly is dissolved, the Speaker shall vacate his or her office immediately. This is not correct. So, A, one only is the right answer. Got it? Very good. With reference to the Speaker of the Lok Sabha, consider the following statements. While any resolution for the Speaker, removal of the Speaker of the Lok Sabha is under consideration. Now, this is a Speaker. Normally, what happens? Speaker does not vote in the first instance. Speaker votes in case there is a tie. Why? Because the logic is that the Speaker should not ideally belong to any ruling party. The Speaker belongs to the House. And the speaker should also be impartial, should also be non-partisan, should not be biased in favor of the ruling party or against the opposition. And how do we ensure? Speaker will not vote in the first instance. For example, the bill is to be passed. The bill is voted upon in the Lok Sabha. There will be some who will vote in favor, some will vote against. Speaker will not vote because I'm impartial. But what if there is a tie? On this bill, 200 people are in favor, 200 are against. Will this bill be passed or not? This is where the speaker has the casting vote. Speaker will vote either in favor or against, just to resolve the deadlock. Otherwise, the bill is stuck. Now, if the speaker votes in favor, the bill is passed. If the speaker votes against, the bill is defeated. But what about when the speaker is to be removed? When the speaker is to be removed, for example, I am the speaker, I am to be removed. Will I sit on the chair of the speaker? No, I will sit in the Lok Sabha. Deputy Speaker will preside over Lok Sabha. In that case, will I vote when there is a tie? No. I will vote in the first instance. Otherwise, it would be violation of the principles of natural justice if I preside over Lok Sabha. And when I'm not presiding over Lok Sabha, I am sitting in the Lok Sabha. I'm just like any other member of the Lok Sabha. I will vote in the first instance. The Deputy Speaker may have a casting vote here because he has the same role as that of the Speaker. So while any resolution for the removal of the Speaker of the Lok Sabha is concerned, are there grounds mentioned in the Constitution on the basis of which the Speaker is to be removed? No. Constitution only says that the Speaker shall be removed by the Lok Sabha based on effective majority. So the Speaker is elected by simple majority, but can be removed from his or her office if a resolution is passed by effective majority. Effective majority means majority of all the then members of the House. Then members means all the members minus vacancies. So we will exclude the vacancies. Whatever else is left, we will calculate the majority. While any resolution for the removal of the Speaker of the Lok Sabha preside, correct, he shall not have the right to speak. Why? You have the right to speak. You can speak in your defense. He shall not be entitled to vote on the resolution in the first instance. Why? In the first instance, you can vote. You cannot vote in case there is a tie, but in the first instance, you can because you're just like any other member. Which of the statements given above are correct? A, one only is the right answer. Clear? Any questions as of now? Okay. Consider the following statements. In the election for Lok Sabha or State Assembly, the winning candidate must get at least 50% of the votes polled to be declared elected. We follow the system of first past the post, where if there are many candidates contesting the election, who will win the election? Somebody who crosses the line for the first time, somebody who gets the highest number of votes. Highest number of, in the election for the Lok Sabha or State Assembly, the winning candidate must get at least 50% of the vote. This is incorrect. You need to get the highest number of votes. According to the provisions laid down in the Constitution of India, in Lok Sabha, the Speaker's post goes to the majority party and Deputy Speaker goes to the opposition. Which of the given statements are correct? Neither one nor two. Why? Because this is not mentioned in the Constitution. This has been a parliamentary convention that the member of the ruling party or the ruling coalition will be elected as the Speaker and the member of the opposition will be the Deputy Speaker. But in the 17th Lok Sabha, which is the last Lok Sabha from 2019 to 2024, and the current 18th Lok Sabha, which is 2024 till present, There is no deputy speaker. Done? Which of the following statements is or are correct? This is about the pending or the bills which get lapsed. There are three things. One is adjournment. The other is prorogation. And the third one is dissolution. House can be adjourned. For example, I was taking the class from 8 o'clock and at 10:04, I told you the session is adjourned. We will meet again 10:20. Which means the session did not end, but there was a brief interval in the ongoing session. That's adjournment. Similarly, it happens in the parliament as well. There is an adjournment. Does adjournment leads to the lapse of bills? No. Does prorogation lead to the adjournment, to the lapse of bills? No. What is prorogation? The session ends. Budget session has ended. Monsoon session has ended. Winter session has ended. What will happen to the bills? The bills will not lapse. If we are unable to discuss these bills in the budget session, we'll discuss them in monsoon session. If not there, then in the winter session, or in the next budget session, or in the next budget session. But then Lok Sabha can be dissolved. Can we say if Parliament is dissolved? No, because Parliament is not dissolved. Because Parliament includes Rajya Sabha as well. And Rajya Sabha is the permanent house of Indian Parliament. It is not subject to dissolution. But when Lok Sabha is dissolved, all kinds of bills lapse. Except three. Which are these three bills which do not lapse? Bills which originate and are pending in the Rajya Sabha. This bill will not lapse. Why? Because the Rajya Sabha is the permanent house of Indian Parliament. A bill which has originated in Rajya Sabha is pending in the Rajya Sabha. It won't lapse. Bills which are awaiting President's assent. Bill has been passed by both houses of the Parliament. It is sent to the President for assent. Now, this bill will not lapse because it has been passed by both the houses. But sir, what if President wants to send this bill back? President can send this bill back to Rajya Sabha because Rajya Sabha is there. And those bills on which the President has notified joint sitting. For example, there was a bill on which there was a deadlock. One house passes a bill, the other house rejects a bill. There is no agreement between both the houses on a particular bill. Now, if the President wants, President can refer this bill to a joint sitting. In joint sitting, there will be both Lok Sabha as well as Rajya Sabha members present. And in that joint sitting, we will pass this bill, we will discuss this bill, we will vote on this bill. And in this joint sitting, Lok Sabha will have the upper hand because of the numerical strength of the Lok Sabha, because Lok Sabha has more members as compared to the Rajya Sabha. So if a bill has been notified already for joint sitting, this bill will not lapse upon the dissolution of Lok Sabha. But listen to me carefully. What if there is a statement that a bill on which there is a deadlock, does this bill lapse upon the dissolution of Lok Sabha? You tell me. I'll repeat the statement. If there is a bill on which there is a deadlock between two houses of the Parliament, will this bill lapse upon the dissolution of Lok Sabha? Which slide is stuck? Is it stuck? This bill will lapse if there is a deadlock. Only those bills will not lapse on which President has already notified that we are going to have a joint sitting for this bill. Otherwise, this bill will lapse. So a bill pending in Lok Sabha lapses on its prorogation. This is incorrect. If it was a bill pending in Lok Sabha lapses on its dissolution, yes, it will lapse. But on prorogation, the bill does not lapse. A bill pending in the Rajya Sabha which has not been passed by Lok Sabha shall not lapse upon the dissolution of Lok Sabha. A bill pending in the Rajya Sabha which has not been passed by Lok Sabha, which means this bill is pending in the Rajya Sabha. It has not been passed by Lok Sabha, which means this bill has originated in Rajya Sabha as well. So a bill which originates and is pending in the Rajya Sabha will not lapse. So which is the correct answer? B2 only is the right answer. Right? Great. The Parliament of India acquires the powers to legislate on any items in the stateless and the national interest if the resolution to that effect has been passed by the... This is related to Article 249 of the Constitution. And whenever, at any point, if there is a provision where Parliament wants to make a law on state list, you have to keep in mind that Rajya Sabha's involvement is necessary. Because the Rajya Sabha is the representative of states. So if the Parliament of India acquires the power to legislate on any item mentioned in the state list, and this is done in national interest, then for that, what do we need? Lok Sabha's approval is not required. Rajya Sabha's approval by simple majority is not required, because you have to make it slightly difficult because we are a federal polity. Rajya Sabha should pass a resolution by flavor 1 of special majority, which is majority of not less than 2/3 of its members present and voting. And what is the validity of such law? This law will be valid for 1 year. Can it be extended further? Yes. Provided Rajya Sabha further approves this bill, this law by another resolution by not less than 2/3 of the members present and voting. This is question 63. 64th question, asked in Prelims 2017. With reference to the Parliament of India, consider the following statements. A private member's bill is a bill presented by a member of Parliament who is not elected but only nominated by the President of India. What is a private member? Who is a private member? A private member is somebody who is not a minister. So is Rahul Gandhi a private member? Yes. A bill introduced by Rahul Gandhi is a private member's bill. Now, what if there is a BJP MP, but who is not a minister in the parliament? For example, we have Mr. What's his name? Any BJP MP who is not a minister in Lok Sabha, or for that matter in Rajya Sabha. Let's say the head of the Delhi BJP, Manoj Tiwari. He is part of the ruling party, but he's not a minister. He becomes a private member. So private member is a member of the parliament who is not a government minister. So a private member's bill is presented by a member of parliament who is not elected but only nominated by the president? No. Even a member who is elected but he is not a minister is a private member, and a bill introduced by a private member becomes a private member's bill. Recently, this was in 2017, private member's bill has been passed in the parliament for the first time in its history. How many private members' bill has been passed by the parliament? Hema Malini, yes, for example, is a private member. In total, 14 private members' bills have been passed in the parliament. 14. 5 of them have originated in Rajya Sabha. 9 of them have originated in the Lok Sabha. So the statement says recently a private member's bill has been passed in the parliament for the first time. This is incorrect. So which of the statements given above are correct? Neither 1 nor 2 is the right answer. Okay? Great. For election to Lok Sabha, a nomination paper can be filed by, if you want to contest election to the Lok Sabha, what is the requirement? First, you have to be the citizen of India. Then you must have completed 25 years of age. Then your name should be mentioned in the electoral roll. That means you should be a registered voter in any parliamentary constituency of this country. That means even if you are a registered voter in Delhi, but you can contest Lok Sabha election from Karnataka. Even if you are from UP and Bihar, you can contest Lok Sabha election from Tamil Nadu. Whether you will win or lose, that's besides the point, but you can contest. So for election to Lok Sabha, a nomination paper can be filed by anyone residing in India. Anyone residing in India can be an alien as well, so that's not possible. A resident of the constituency from which the election is to be contested? No, even if you are a resident of Delhi, but you can contest election from Coimbatore. Any citizen of India whose name appears in the electoral roll of the constituency. Maybe. Any citizen of India. Even if you are a citizen, that does not entitle you to contest elections. Why? Because there is an age criteria. A 1-year-old is also a citizen, but can you contest elections? Even if you are a citizen, but your name is not on the electoral rolls, you cannot contest elections. So the answer is any citizen of India whose name appears in the electoral roll of any constituency. C is the right answer. Can a nominated member be a minister? Yes, nominated member can also be a minister. When a bill is referred to a joint sitting of both the House of the Parliament, it has to be passed by simple majority of the members present and voting. That is why we say in joint sitting, Lok Sabha prevails over Rajya Sabha. Clear? Which of the following committees is the largest committee of the Parliament? For example, if you look at Committee on Public Accounts, it has 22 MPs, members, 15 from Lok Sabha, 7 from Rajya Sabha. But if there is a committee which is considered to be the largest committee of the Parliament, it is the Committee on Estimates. How many members do they have? 30 members. And these 30 members are exclusively from Lok Sabha. So B is the right answer. Consider the following statements. The Rajya Sabha has no power either to reject or amend a money bill. This is correct. Rajya Sabha can only make recommendation. The Rajya Sabha cannot vote on the demands for grants. Correct. Because voting on the demands of grants is exclusive power for the Lok Sabha. Rajya Sabha cannot discuss the annual financial statement. Now this is incorrect. Rajya Sabha can also discuss and does discuss annual financial statement. In fact, after the finance minister presents the budget in the Lok Sabha, it is presented in the Rajya Sabha then after the finance minister's speech. And then in both houses of the parliament, there is a general discussion on annual financial statement, which lasts for a few days. Which of the statements given above are correct? B, 1 and 2 is the right answer. Okay. Any questions as of now? Then you accuse me of not checking the chats. Because either I can discuss the question or discuss the chat. I can't do both. This level of multitasking I'm not accustomed to. What will follow if a money bill is substantially amended by the Rajya Sabha? Now, Rajya Sabha cannot amend. Rajya Sabha can only make recommendation. But be that as it may, let's look at what the question is. Lok Sabha may still proceed with the bill accepting or not accepting the recommendations of the Rajya Sabha. Let's see. Lok Sabha cannot consider the bill further. You have to just keep in mind that Rajya Sabha has an inferior role as compared to Lok Sabha when it comes to a money bill. So this can't be the answer. Lok Sabha may send the bill to Rajya Sabha for reconsideration. What is this? Is this post office? Lok Sabha passes a bill, Rajya Sabha amends a bill, then Lok Sabha does not accept, then you send it back for reconsideration? No. the president may call for a joint sitting. On a money bill, there is no joint sitting. Why? Because a money bill can be passed by Lok Sabha, then it is sent to Rajya Sabha. Rajya Sabha cannot reject a money bill. Rajya Sabha cannot amend a money bill. Even if Rajya Sabha does not act on the money bill for 14 days, at the end of the 14-day period, at the expiry of the 14-day period, it shall be construed that both houses of the Indian Parliament have passed the money bill. So Lok Sabha may still proceed with the bill, either accepting or not accepting the recommendations. So here amendment is wrongly used, but here recommendations are correctly used. A deadlock between the Lok Sabha and the Rajya Sabha calls for a joint sitting of the Parliament during the passage of. Now, what causes a deadlock? For example, there is a bill A. This bill, let's assume there is Lok Sabha, there is Rajya Sabha. If Lok Sabha, I'll use a different color here. If Lok Sabha passes this bill, Rajya Sabha also passes this bill, there is no problem, no dispute. Lok Sabha passes this bill, Rajya Sabha rejects this bill. When Rajya Sabha rejects, there is a deadlock. Lok Sabha passes this bill, Rajya Sabha amends this bill. And if Rajya Sabha amends this bill goes back to Lok Sabha. If Lok Sabha passes the same bill again, and then it is sent to Rajya Sabha amends this bill again, there is a deadlock. Lok Sabha passes this bill, Rajya Sabha does not act on this bill for 6 months. Then there is a deadlock. And to resolve this deadlock, then there is a joint sitting. I can even change Rajya Sabha to Lok Sabha. For example, a bill was passed by Rajya Sabha, it is rejected by Lok Sabha, deadlock. A bill was passed by Rajya Sabha, Lok Sabha does not act on this bill for 6 months, deadlock. A bill was passed by Rajya Sabha and Lok Sabha amends it, this bill goes back to Rajya Sabha. Rajya Sabha amends it, then again there is a deadlock. And to resolve this deadlock, there is a joint sitting. This joint sitting can be for an ordinary legislation. Can it be for a money bill? No, because Rajya Sabha has an inferior role. Can it be a constitutional amendment bill? No, because a constitutional amendment bill shall have to be passed by both houses of the Indian Parliament separately, and there is no provision for a joint sitting. So A, one only, is the right answer. Yes? Sumit Parashar, you're wrong. It is A. Let's look at question 71. With reference to Indian Parliament, consider the following statements. A bill pending in Lok Sabha lapses on its dissolution. We discuss the bills here. Keeping this concept in mind, let's look at the statement. Let's look at the question. A bill pending in Lok Sabha lapses on its dissolution. Yes or no? Yes. A bill passed by Lok Sabha and pending in the Rajya Sabha lapses on the dissolution of the Lok Sabha. A bill passed by Lok Sabha, now it is pending in the Rajya Sabha. Will it lapse or not? But Rajya Sabha is a permanent house, not subject to dissolution. A bill passed by Lok Sabha and pending in the Rajya Sabha lapses, yes, because both conditions have to be satisfied. If a bill originates in Rajya Sabha and is pending in Rajya Sabha, it won't lapse. But if the bill has originated in Lok Sabha and now is pending in Rajya Sabha, it will lapse. A bill in regard to which the President of India has notified his or her intention to summon the houses to a joint sitting lapses on the dissolution of the Lok Sabha. No, because such a bill does not lapse. Which of the following statements are correct? Above statements are correct. 1 and 2, B is the right answer. Okay? Great. Now again, those who have not liked the session yet, press the like button and then we will start again. Otherwise, I will end the session after we are done with all the questions. Consider the following statements regarding a no confidence motion in India. There is no mention of no confidence motion in the Constitution of India. This is correct. Where is it mentioned? It's mentioned in rules of business and procedure of Lok Sabha. Constitution only says the Council of Ministers shall be collectively responsible to Lok Sabha. Now, which are those tools through which we can ensure collective responsibility of Council of Ministers to Lok Sabha? These tools are mentioned in rules of business and procedure. For example, confidence motion, adjournment motion. A motion of no confidence can be introduced in Lok Sabha only. Yes, because Council of Ministers are collectively responsible only to Lok Sabha, not to the Rajya Sabha. So C, both 1 and 2 is the right answer. Okay, great. In the Parliament of India, the purpose of an adjournment motion is what? One is adjournment. Adjournment is done by the presiding officer. Something I was telling you previously about, that we adjourned the session at 10:04 p.m. and I told you that we will be back at 10:20. Adjournment is done by the presiding officer, the speaker, deputy speaker, or anyone from the panel who is presiding over the house. But this is adjournment motion. If 50 MPs write to the speaker, that speaker, we have an agenda, because normally there is an agenda for the house. What exactly are we going to discuss? For example, we have an agenda for this Conquer Prelims. In the first phase, we discuss current affairs from January to May 2024. In the second phase, we discuss high yielding topics. This is the third phase where we are discussing the PYQs. Then we will come across fourth phase where we will discuss current affairs from May to April 2025. Then there will be phase 5. So this is the agenda. Similarly, Parliament also has an agenda that we will discuss these bills, these motions, these resolutions. But if the 50 MPs of Lok Sabha write to the speaker that we want to adjourn this agenda, instead of this agenda, we want to discuss a matter of urgent public importance, then this agenda will be adjourned and what will be discussed is the matter of urgent public importance. And the discussion should be more than 2.5 hours. The discussion on this matter of urgent public importance should be for more than 2.5 hours. And if this adjournment motion is then passed, because after the discussion, there is voting as well. And if this adjournment motion is passed by simple majority, it amounts to censure of government. That means we can assume that the government has lost the confidence of the Lok Sabha, because by simple majority, adjournment motion has been passed. So in the Parliament of India, the purpose of adjournment motion is to allow a discussion on a definite matter of urgent public importance. Yes, but let's look at other statements. To let opposition members collect information from the ministers. For that, you have question hour. To allow reduction of specific amount in demand for grant. For that, we have cut motions. For example, economy cut. To postpone the proceedings to check the inappropriate or violent behavior on part of some members. No, that has got nothing to do with adjournment. So A is the right answer. Okay? Great. Now, which of the following are the methods of parliamentary control over public finance in India? Again, Prelims 2012, important topic, can be asked again in the exam. That's why we have discussed this. Parliamentary control over public finance. We say what is the role of Parliament, which means what is the role of the legislature? To keep a check on the government, to keep a check on the executive. How does Parliament keep a check on the executive? Through questions, motions, resolutions, passing of budget. Because budget cannot be passed without the approval of the Parliament. Not even a single penny can be withdrawn from the Consolidated Fund of India unless and until an appropriation bill is passed by the Parliament. Cut motions are introduced. Policy cut motion, economy cut, token cut. All these are the tools through which Parliament exercises control over the executive when it comes to public finance. What are the specific tools? Placing annual financial statement before the Parliament. Placing budget before the Parliament. What if budget is not passed? The government is defeated on the floor of the Lok Sabha. The government has to resign. Withdrawal of money from Consolidated Fund of India only after passing the appropriation bill. What if Parliament does not approve? Provisions of supplementary grants and vote on account. 100 crores were given to a ministry to be spent on in a financial year between 1st of April till 31st of March. What if you exhausted this money in December? For January, February, March, you have nothing to spend. What will happen? Supplementary grants will be released by the Parliament. Supplementary grants is also a check. Parliament will ask you questions. Why did you spend the money even before the well of the time? A periodic or at least a mid-year review of programs of the government against macroeconomic forecast and expenditure by Parliamentary Budget Office. Such a thing does not exist. So there is no mid-year or yearly review of government programs. Introducing finance bill in the Parliament, which means introducing a bill which is part of the budget, which talks about taxation proposals. 1, 2, 3, 5. A is the right answer. Clear? Where does that money come from? That money comes from the Consolidated Fund of India. What is vote on account? Vote on account previously used to be part of every budget, which means after the general discussion of the budget was over, because what are the various stages through which a budget passes? Budget is presented before the Parliament by the Finance Minister. She gives a speech, sometimes sitting, sometimes standing, sometimes sipping water, sometimes quoting Thruvalar, sometimes quoting others. And then after that speech is over, the budget is tabled in both houses of the Parliament, and then there is a general discussion. After the general discussion is over, then both houses of the Parliament are adjourned for 3 to 4 weeks. And this is where 24 departmentally related standing committees, they review these demands for grants. But after the general discussion was over, vote on account used to be passed. Vote on account means the government can spend money for 2 months. Because previously what would happen, the budget would be passed after the financial year, which means the budget would be cleared by the Parliament after 31st March. But after 31st March, what will you spend? Because for budget, there is a rule called rule of lapse. Because the money which was given to you by the Parliament was available only for one year. What if there is a money which is now unspent? It will go back to Consolidated Fund of India, which means after 31st of March, from 1st of April, you have no money to spend. And the budget for the next financial year is still not passed. For that intervening period, for 2 months, vote on account was passed, which means it allowed the government to spend money for 2 months. But now vote on account is no longer part of the budget. It is only a part when the government in an election year presents vote on account. Because in an election year, the government does not present a full-fledged budget. It only presents a vote on account. And then once the new government is formed, that new government presents something called interim budget. Okay? Great. Question 75. With reference to the Parliament of India, consider the following statements. Prorogation of House by the President of India does not require advice of the Council of Ministers. Now, President can do nothing without the advice of the Council of Ministers. President can summon Parliament, can adjourn Parliament. President can summon Parliament or terminate the session of the Parliament or dissolve Lok Sabha only on the advice of the Prime Minister. So, prorogation of House by the President does not require the advice. This is incorrect. It does require. Prorogation of House is generally done after the House is adjourned sine die, but there is no bar to the President of India prorogating the House which is in session. Now, adjournment is of 2 types. Adjournment with date and time specified and adjournment sine die. For example, I am the presiding officer of the Lok Sabha and the session lasts till today. For example, the session was summoned by the President and President said the session will last for 10 days, which means today, 22nd of March, is the last day of the session. Today, when I'm adjourning the session, adjourning the House, can I adjourn the House by specifying the date and time when we are going to meet again? No. Why? Because I don't know when the Parliament will be summoned again, when the President will summon again. So what the presiding officer does, on the last day of the session, he says the House is adjourned sine die without mentioning the date and time on which we are going to meet again. And then it paves way for the President to prorogue the session, to terminate the session. So prorogation of the House is generally done after the House is adjourned sine die. But sometimes the President can prorogue the House at any point on the advice of the government. Dissolution of Lok Sabha is done by the President of India, who, save in exceptional circumstances, does so on the advice of the Council of Ministers. 2 and 3 is the correct. Can Lok Sabha be dissolved? Yes. That's what we call the dissolution of the Lok Sabha. Dissolution is of two types: premature and once the term is over, or should we say automatic. What is the term of the Lok Sabha? The term of the Lok Sabha is 5 years. Once 5 years is over, President will dissolve Lok Sabha automatically because the term is over. But sometimes even before 5 years, the President can dissolve Lok Sabha, but that is only on the advice of the Prime Minister. And is this advice binding on the President? Yes. But what if a no confidence motion is passed against the Prime Minister and the Council of Ministers in the Lok Sabha? Now I am the Prime Minister, but I have been defeated in the Lok Sabha. I have lost the confidence of the Lok Sabha. And I am advising the President, please dissolve Lok Sabha. Now this advice is not binding on the President. He may still dissolve Lok Sabha, but it is not binding on him. Why? Because the advice is coming from a Prime Minister who has been defeated on the floor of the Lok Sabha. So dissolution of Lok Sabha is done by the President, who, save in exceptional circumstances, does so on the advice of the Council of Ministers. 2 and 3 is the right answer. Clear? Done. The Parliament of India can make law for whole or any part of India for implementing international treaties. And this is under the provisions of Article 253 of the Constitution. Parliament can enact a law to implement international treaties without the consent of any state. The consent of state is not required. Where is the consent of state required? For example, Article 252, where if two or more states request the Parliament that their Parliament please enact a law on state list. This is at the consent, at the request of the states. But under Article 253, even without the consent of the state, it can implement any international treaty. For example, Lokpal and the Lokayukta Act of 2013. It was enacted by the Indian Parliament, keeping in mind the United Nations Convention Against Corruption, which we had ratified in 2008. Which of the following special powers have been conferred on Rajya Sabha by the Constitution? Rajya Sabha has 3 special powers. One is Article 67 Clause B, which talks about the removal of the Vice President. The other is Article 249, which we discussed previously, where on the recommendations of the Rajya Sabha, only on the recommendations of the Rajya Sabha, if the Rajya Sabha passes a resolution by not less than 2/3 of the members present and voting, then Parliament can enact a law on state list. And the other is Article 312. And Article 312 talks about creation of a new All India service. These are the three special powers of Rajya Sabha. To change the existing territory of a state and to change the name of a state? No. To pass a resolution empowering the parliament to make laws in the state list and to create one or more all India services? Yes. To make laws in the state list means Article 249. To create a new all India service means Article 312. To amend the election procedure of the president and to determine the pension of the president after his retirement, to determine the functions of the election commission and to determine the numbers of the election commissioners. That power is with the parliament. Clear? Let's look at question 78. Consider the following statements. If the election of the president is declared void by the Supreme Court, all acts done by him or her in the performance of duties of his or her office before the date of decision become invalid. No, they remain valid. Now here one thing you have to keep in mind, that Supreme Court has the exclusive jurisdiction. That means if there is an issue with regards to the election of the president or the vice president, such a matter can be referred only to the Supreme Court. That means an election petition can be filed only in the Supreme Court. That means Supreme Court has the exclusive jurisdiction to hear cases challenging the election of the president or the vice president. And what if the president's election is declared void? That means this election is null and void, which will happen obviously after the president is elected. During that period, president would have taken various decisions. What will happen to those decisions? Will they remain valid or invalid? They will remain valid. This is mentioned in the Constitution. Elections for the post of President of India can be postponed on the grounds that some legislative assemblies have been dissolved and elections are yet to take place. Constitution says if there is a vacancy in the Electoral College. What is the Electoral College? Electoral College consists of elected members of both houses of the parliament, elected members of the state legislative assemblies. What if there is a legislative assembly where there is president's rule? Either the legislative assembly is dissolved or suspended. Those MLAs are not part of the election. On this ground that there is a vacancy in the Electoral College, can the elections for the post of president be postponed? No. In fact, once there was a vacancy in the Electoral College because Rajasthan MLAs were not present. Rajasthan Legislative Assembly was dissolved. In fact, matter went to the court. Court said, no, you can't do that. Even if there is a vacancy in the Electoral College, that does not mean election to the post of the president will remain vacant. It is as if there are 1 lakh voters in a constituency, but 50,000 don't come out and vote. On that ground, can we declare the election null and void? No. When a bill is presented to the President of India, the Constitution prescribes time limits within which he or she has to decide his or her assent. There is no time period. And the reason why when there is no time period, that is what led to the emergence of pocket veto. So which of the statements are correct? D, none. None of these statements are correct. 79. The President of India can summon a session of Parliament at such place or places as she or she thinks fit. Can there be a session of the Parliament in Delhi? Yes. Can there be a session of the Parliament in Chennai? Yes. The Constitution of India provides for 3 sessions of the Parliament in a year, but it is not mandatory to conduct all the sessions. Constitution does not provide for 3 sessions. Yes, we have 3 sessions in the form of budget session, in the form of monsoon session, in the form of winter session, but these are mentioned in the rules of business and procedure. Constitution has only one requirement, that Parliament must meet in such a manner that the time gap between the last day of the previous session and the first day of the next session should not be more than 6 months. Which means Parliament must meet at least 2 times in a year. There is no minimum number of days that the Parliament is required to meet in a year. There is no minimum number. The only requirement is that the Parliament must meet in such a manner that the time between the last day of the previous session and the first day of the next session should not be more than 6 months. That's it. So which of these statements are correct? 1 and 3, C is the right answer. Right or wrong? Okay. Question number 80. Which one of the following suggested that the governor should be again a mistake here, it should be eminent. No, it is fine. Eminent member, eminent person from outside the state and should be a detached figure without intense political links? Who suggested this? This is suggested by the Sarkaria Commission on Center-State Relations, which was established in 1983, although it gave its report in 1988 after 5 years. Sarkaria Commission had suggested that governor should be a detached political figure. He should not be too involved in the politics. In fact, it also suggested that a member of the ruling party at the center should not be appointed as a governor to a state which is ruled by the opposition. It also suggested that this doctrine of pledger should be removed from the constitution. Sarkaria Commission, C is the right answer. Which of the following are not necessarily the consequences of the proclamation of president's rule in a state? President's rule is imposed under Article 356 if the president is satisfied on the report of the governor or even otherwise. That means the report of the governor is not necessary for the declaration, for the imposition, for the proclamation of the president's rule. But Article 356 says if the president is satisfied on the basis of the report of the governor or even otherwise that there is a breakdown of constitutional machinery, then what the president can do? President can proclaim president's rule. And the first casualty, the immediate casualty is removal of Council of Ministers in the state. Immediately they are sacked. For example, president's rule was imposed in Manipur. Chief Minister and the Council of Ministers gone. Although there wasn't a Chief Minister at that time, Biren Singh had resigned. But the Council of Ministers gone. Although there wasn't even a Council of Ministers, because with the resignation of the Chief Minister, the Council of Ministers is also gone. But whenever there is a president's rule, the first casualty is Council of Ministers are gone, dismissed, removed. But what happens to Manipur Legislative Assembly? Right now, is it dissolved? No. It is kept under suspended animation. Because tomorrow, if the MLAs who are part of the Manipur Legislative Assembly, if they have an agreement over the choice of the Chief Minister, the name of the Chief Minister, the government can be formed and the suspended Legislative Assembly can be revived. So which of the following are not necessarily the consequences of imposition of the president's rule in a state? Dissolution of the state legislative assembly. It is not necessary. Yes, if no government is possible, then the legislative assembly is dissolved and then only option is fresh election. Removal of the chief council of ministers. No, it is a consequence. Necessary consequence. Dissolution of local bodies. Local bodies have got nothing to do with Article 356. Article 356, in fact, has got nothing to do with fundamental rights. Nothing will happen to your fundamental rights if there is president's rule in your state. And nothing will happen to your local bodies, your Panchayati Raj institutions, your urban local bodies will continue. Select the correct answer using the code given below, 1 and 3. Because which of the following are not necessarily the consequence? 1 and 3 is not necessarily the consequence. But necessary consequences too, because immediately the Council of Ministers are sacked. Okay? The Parliament of India exercises control over the functions of the Council of Ministers through, and I told you previously, that Parliament exercises control over the executive through various means. Adjournment motion, yes. Question hour, yes. And in question hour, the questions can be either starred or unstarred or short duration questions. Start question means that I need an answer to this question orally. Unstart question means I need an answer to this question in a written format. Supplementary questions, yes. This is how Parliament exercises control over the executive. 1, 2, 3 is the right answer. Which one of the following are the discretionary powers of the governor of a state? Because Constitution says under Article 163 that there shall be Council of Ministers with the Chief Minister at the head to aid and advise the governor, who shall act on that advice, except when the governor has to act in his discretion. Discretion means when the governor does something without the aid and advice of the Council of Ministers. But what are these discretionary powers of the governor? These are not defined in the Constitution. But what Constitution does say is that if there is a dispute as to what constitutes the discretionary power of the governor, the word of the governor shall be final, which means the governor of the state gets to decide what are his or her discretionary powers. And this, you would know, is the bone of contention between the elected chief ministers and the appointed governors, particularly in the opposition ruled states, for example, Kerala, for example, Tamil Nadu, for example, Bengal, for example, Telangana, for example, Punjab. What are these discretionary powers? Sending a report to the President of India for imposing President's rule. This is discretionary because will the governor take the advice of the Council of Ministers to recommend President's rule? Because which chief minister will advise? Appointing the ministers? No, it is not a discretionary power. Because Constitution says if it was appointment of the chief minister, that's a discretionary power of the governor, because Constitution says the chief minister shall be appointed by the governor. Who that chief minister is, that we don't know. But then other ministers shall be appointed by the governor on the advice of the chief minister. So appointing other ministers is not the discretion, but appointing chief minister is a discretion. Although that is something that we call a situational discretion. If there is a situation where no political party has the majority, which means we don't have the leader of a political party who has the majority in the Legislative Assembly, in that case, governor can appoint anyone as the chief minister. Reserving bills passed by the state legislature for the consideration of the president. For that, just look at what the Tamil Nadu chief governor has done. Mechanically reserved all the bills for the consideration of the president. That's what previous Kerala governor did. Making rules to conduct the business of the state government? No, this you have to do on the advice of the chief minister. Because when you exercise your executive powers, these executive powers are to be exercised on the advice of the chief minister. So 1 and 3B is the right answer. Done? Okay. The Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution to that effect is passed by, and this is something that we covered previously as well. Repeat. Rajya Sabha by a majority of not less than 2/3 of its members present and voting. D is the right answer. Question 85. Consider the following statements. The Legislative Council of a state can be larger in size than half of the state Legislative Assembly. The governor of a state nominates the chairman of the Legislative Council of that particular state. Now, do we have legislative councils in India? Yes. There are certain states where we have a bicameral legislature. Bicameral legislature, that means we have both legislative assembly, we have legislative council as well. Which are these states where we have a legislative council? For example, we have Andhra, Telangana, Maharashtra, Bihar, UP, Karnataka. This is where we have a bicameral legislature, the second house, the Legislative Council. Does Constitution provide for a number that for Legislative Council in Andhra, this should be the number, this should be the composition? No. Constitution has provided for a range. And the range is that minimum we can have 40, Maximum we can go up to is 1/3 of the strength of the Legislative Assembly. So Legislative Council of a state can be larger in size than half of the Legislative Assembly? No, 1/3. Incorrect. The governor of a state nominates the chairman of the Legislative Council of that particular state. No, the chairman is elected. The Legislative Council has a deputy chairperson and a chairman. And both of them are elected, which means both of them are members of the Legislative Council. They're MLCs. Unlike the chairperson of the Rajya Sabha, who is the vice president of India, the ex officio chairperson of the Rajya Sabha, and the vice president is not the member of the Rajya Sabha, but the chairman of the Legislative Council is a member of the Legislative Council, and you are elected, not nominated. So which of these statements given above is or are correct? Neither one nor two, both the statements are incorrect. D is the right answer. Okay? We still have more than 40 questions to discuss, and here we will take a break of 15 minutes. We will come back at 12:10 a.m. Stay with me. We will discuss some important things. If I can be awake for you, you should be awake for yourselves. See you on the other side of the break. Don't go away. Good morning, everyone. Shall we resume? Let's look at the topics from the judiciary. This was asked in 2023. In India, which one of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretations of the fundamental rights? And to tell you, this question was removed by UPSC. Why? I don't know, but the answer to this question would be the First Amendment. Because the first constitutional amendment, it inserted Article 15, Clause 4. Why? Because there was a judicial interpretation of fundamental rights. The directive principles are inferior, fundamental rights are superior. Similarly, when Land Reform Zamindari Abolition Act was declared unconstitutional, because you are violating fundamental rights under Article 14, 19 and 31. That's how first Constitutional Amendment Act was passed, Article 31 capital A, Article 31 capital B. The 9th schedule got added to the Constitution. Clear? Also because one more reasonable restriction was added to your freedom of speech and expression on the grounds of public order. Because one particular magazine, it was banned in the state of Madras. So the answer to this question could be the first constitutional amendment. Okay. Consider the following statements. The Supreme Court of India has held in some judgments that the reservation policies made under Article 16, Clause 4 of the Constitution would be limited by 335 for maintenance of efficiency in administration. For example, the Supreme Court in Indrasani v. Union of India in 1991-93, what they said, that yes, reservation for OBCs is constitutional in public employment. But this has to be done if 5 constitutional requirements are met. Which are these 5 constitutional requirements? One, you have to convince that these communities for whom you are providing reservation, these are socially and educationally backward. That's number one. Number two, that they are not adequately represented in the administration. Number two. Number three, that a concept of creamy layer shall apply. Number four, that reservation cannot, unless extraordinary situations are there, exceed 50%. And fifth, efficiency in administration should not be affected, should not be flirted with. And that is under Article 335 of the Constitution. But what is this efficiency in administration is not defined in the Constitution. So statement 2 is incorrect. So statement 1 is correct, but statement 2 is incorrect. C is the right answer. Question 88. With reference to the writs issued by the courts in India, consider the following statements. This was asked in 2022. This is related to, one is related to mandamus. The other is related to quo warranto. Because if your fundamental rights are violated, you can approach the Supreme Court under Article 32. You can approach the High Courts under Article 226. And Supreme Court and High Court will issue writs to protect your fundamental rights. And this is where we come across a term called locus standi. Who can approach the court? If only an agreed individual whose rights have been violated, if only such people can approach the court, we say concept of locus standi applies. If anybody can approach the court, even if you are not an agreed individual, we say locus standi does not apply. Locus standi does not apply where? In case of habeas corpus and in case of quo warranto. Because any public-spirited individual can approach the court. But in case of mandamus, certiorari, prohibition, locus standi applies, which means only an aggrieved individual can approach the court. And what is mandamus? You approach the courts so that the courts can say, we command, we direct that you perform that duty, and that duty has to be a public duty. If an organization which has to perform this public duty is not performing this duty, you can approach the court and the court will issue the writ of mandamus saying, we command you perform this duty. That's why we say, can you approach the court for a writ of mandamus if you are not following fundamental duties? No, because fundamental duties are not legal duties. Mandamus will not lie against a private organization unless it is entrusted with a public duty. Mandamus can be issued by the courts against any organization, if it has to perform a public duty. So even if it's a private organization performing a public duty, writ of mandamus can be issued. Mandamus will not lie against a company even though it may be a government company. Correct? That means even if you are a government company, but you are not performing a public duty, mandamus cannot be issued. So just because you are a government company, but you are not performing a public duty, that does not mean you can get the writ of mandamus issued by the Supreme Court. Any public-minded person can be a petitioner to move the court to obtain the writ of quo warranto, which means the locus standi does not apply. So 1, 2, 3, D is the right answer. On this question, any questions? No. Consider the following statements. Pursuant to the report of the H.N. Sanyal Committee, the Contempt of Courts Act was passed. This is true. On the basis of the recommendations of the Sanyal Committee. The Constitution of India empowers the Supreme Court and High Courts to punish contempt for themselves. Correct. Who can punish for contempt? Those who are the court of record. And in India, who is the court of record? It is the Supreme Court and the High Courts. Which means, can a district court punish somebody for committing contempt? No. Does that mean that you can commit contempt to the district court? No. Because if you're committing contempt to the district court, the High Court of that state can punish you. That means High Court of the state is empowered to punish people for contempt on behalf of the district court. But district courts themselves cannot punish people for contempt. The Constitution of India defines civil contempt and criminal contempt? No. This is something which is defined in the Contempt of Courts Act 1971. In India, the Parliament is vested with the powers to make laws on contempt of court. Yes, this follows Statement 1 because when Contempt of Court Act was passed in 1971, which means Parliament is empowered to make laws related to contempt. And significant amendments were made in the year 2006 when the Parliament said truth is a valid defense in case there is a contempt charge against you if you are saying truth. So 1, 2, 4, B is the right answer. With reference to Indian judiciary, consider the following statements. Any retired judge of the Supreme Court can be called back to sit and act as the Supreme Court judge by the Chief Justice of India with the permission of the President of India. This is correct. Can a retired judge of the Supreme Court practice as a lawyer before the Supreme Court? No. But can you be called to preside over a particular case? Yes. If there is a judicial backlog, if the Supreme Court Chief Justice decides, with the prior approval of the President and with the consent of this retired judge, because the consent of retired judge is also necessary. A High Court in India has the power to review its own judgment as the Supreme Court does. This is not correct. 1 only is the right answer. For example, when we look at the fact check unit, this was a petition filed before the Bombay High Court by comedian Kunal Kamra. On that, there was a split verdict. That means one judge was in favor of this fact check unit, the other was not. Then a third judge was appointed to hear this particular case, and this third judge also said fact check unit is unconstitutional. So we can say that yes, high courts can also have the power to review their own judgments. But just like the Supreme Court does, no. Because the Supreme Court has various ways of reviewing its own judgment in the form of review petition, in the form of curative petition. That is something which is not a provision for a high court judge. So a high court judge has the power to review its own judgment just like the Supreme Court does, as the Supreme Court does? No. So one only, A is the right answer. Okay. In India, separation of judiciary from the executive is enjoined by, I told you previously, the state shall take steps to separate executive from the judiciary. And this is a directive principle of the state policy. B is the right answer. With reference to India, consider the following statements. When a prisoner makes out a sufficient case, parole cannot be denied to such a prisoner because it becomes a matter of his right. Parole is not a right. Furlough is a right. So statement 1 is incorrect. State governments have their own prisoners released on parole rules. Yes. Why? Because prison, they come under state list. In the distribution of powers under Schedule 7 of the Constitution. So which of the given statements are correct? B, 2 only is the right answer. With reference to India, consider the following statements. Judicial custody means an accused is in the custody of the concerned magistrate, which is true, and as such, accused is locked up in the police station and not jail. Judicial custody and police custody. If it is judicial custody, you are in jail. If it is police custody, you are in police lockup. If you are in police custody, police can interrogate you at any point in time. But if you are in jail, the police needs the permission of the court to carry out and to perform the interrogation. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. This is correct. So which of the statements are correct? B, 2 only is the right answer. Right? Very good. Consider the following statements. The motion to impeach. Now, impeachment is a term that we use only for the President of India. But if UPSC is using this, we can't question them either. Although the correct term should have been removal, because only the President is impeached. Vice President, Prime Minister, CAG, judges, CEC, UPSC chairperson, all these can be removed. The motion to impeach a judge of the Supreme Court cannot be rejected by the Speaker of the Lok Sabha as per the Judges Inquiry Act. This is incorrect. Because at that time, there was a controversy over the then Chief Justice of India, Justice Deepak Misra, against whom the opposition introduced a motion calling for his removal. But it was rejected by the chairperson of the Rajya Sabha, the then Vice President, Mr. Venkaiah Naidu. So according to the Judges Inquiry Act, yes, the Speaker has the discretion. The chairman of the Rajya Sabha has the discretion to either accept or reject it. The Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court of India. No. The judges can be removed from their office, although the judges have a well-defined tenure. The Supreme Court judge remains in office till the age of 65. The High Court judge remains in office till the age of 62. But even before completing this age, this term, this tenure, you can be removed. On what grounds? On the grounds of proved misbehavior or incapacity. But is that defined in the Constitution? No. That is defined where? In this law called Judges Inquiry Act of 1968. Which means for that a committee has to be set up. This committee will consist of Chief Justice of India or a senior Supreme Court judge nominated by the Chief Justice of India, the Chief Justice of a High Court, and a distinguished jurist. For example, when Justice Veeraswamy was to be removed by the Parliament, for that a committee was set up and the committee said, yes, the charges of misbehavior and incapacity have been proven against Justice Ramaswamy. And at that time, the distinguished jurist nominated by the chairperson was Falias Nariman. So the details of the process of impeachment of the judges are given in the Judges Inquiry Act. Yes. If the motion for impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by the majority of total membership of the house and by not less than 2/3 of the members present and voting. 3 and 4 is correct. Because when this committee submits a report, this report is binding as well as not binding. Binding in the sense, if the committee says, no, the charges of misbehavior and incapacity have not been proven, Parliament cannot go ahead and remove the judge. But if the committee says, yes, the charges have been proven, Parliament may still not go ahead, because for that you require parliamentary approval, parliamentary majority. And this is a very tough majority to obtain, special majority flavor too. That is why when Justice Ramaswamy was to be removed, despite the fact that the committee said, yes, the charges have been proven, but the Congress party abstained from the voting. Abhishek Manu Singhvi was defending the judge in the parliament. Because this removal process becomes Parliament's quasi-judicial function. So 3 and 4 is the right answer. Now maybe a judge can be impeached soon. You never know. I was just checking the news. The Supreme Court has made public the inquiry report. What that inquiry report says, we will have to wait and watch. Question number 95. The 44th Amendment to the Constitution of India introduced an article placing the election of the Prime Minister beyond judicial review. Even if you don't know this, but use your common sense, which is not so common, but you can use it. 44th Amendment was primarily introduced to undo the damage caused to the Constitution when Indira Gandhi was the Prime Minister by the 42nd Constitutional Amendment Act 1976. So this is like a damage to the Constitution. This damage could have been undone by 44th Amendment, not perpetrated by 44th Amendment. That's the logic. That's the common sense that you have to make. This was done by 42nd Amendment. Or this was done even prior to that by 39th Amendment, 41st Amendment, when the election of the Prime Minister was removed from judicial review. The Supreme Court of India struck down 99th Amendment. 99th Amendment led to the enactment of creation of NJAC, National Judicial Appointments Commission. And this NJAC was sought to replace the collegium system. This, the Supreme Court said, is unconstitutional. Why? Because it violates independence of judiciary, which is part of the basic structure. It also violates primacy of Chief Justice of India in judicial appointments. Now, what is this primacy of Chief Justice of India? This is a euphemism for virtual veto for the Chief Justice. Because right now there is a virtual veto for the Chief Justice. Any name which is not acceptable to the Chief Justice of India cannot be sent to the President for appointment. So in judicial appointments, Chief Justice of India has a veto. In NJAC, that veto was not given to the Chief Justice. So Supreme Court said primacy of Chief Justice of India in judicial appointments, which means the veto of the Chief Justice of India in judicial appointments. It's also part of the basic structure. So which of these statements are correct? Only 2B is the right answer. Right? Great. With reference to the Constitution of India, consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally valid. No. High Courts can also do that. In fact, I've told you previously that the first Constitutional Amendment Act was triggered by the Patna High Court judgment. High Courts have the power to even strike down a central law. An amendment to the Constitution of India cannot be called into question by the Supreme Court. Supreme Court has the power of judicial review. Previously, we discussed 99th Amendment was declared unconstitutional by the court. Which of these statements are correct? D. Neither one nor two. Right? Any questions? Okay. With reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which of the following? Article 142 gives power to the Supreme Court. This power is available only to the Supreme Court, not to the High Courts. That you can give any order so as to give complete justice. For example, recently it was invoked when a Dalit boy could not secure the admission in an IIT because he failed to deposit the fee during the window provided. Ultimately, he had to go to the court, and the Supreme Court said, we will issue Article 142. We will issue an order to give complete justice. Even if the time has lapsed, you can still get the admission by paying this fee. So is it related to Election Commission? No. Is it related to the president to declare financial emergency? No. Is it the state legislatures cannot make laws on certain matters without the concurrence of the union legislature? No. In fact, such a system does not exist. It is the Supreme Court is not constrained, is not limited in the exercise of its powers by the laws passed by the Parliament, which means Article 142 is a plenary power of the Supreme Court. Plenary power, that means while the court is exercising these powers, it is unrestricted by executive, unrestricted by the government. You can issue any order so as to give complete justice. In India, judicial review implies what? The power of judiciary to pronounce upon the constitutionality of laws and executive orders. Let's see. The power of judiciary to question the wisdom of the laws enacted by the legislature, although that is also judicial review, because this is something that we follow in due process of law. The courts can get into the intention of the legislature behind enacting those laws. Yes. The power of judiciary to review all legislative enactments before they are assented to by the president. This is incorrect, purely incorrect. Why? Because Supreme Court or courts cannot be asked to answer hypothetical questions. Otherwise, you are wasting the time of the court. Can we go to the Supreme Court and ask the Supreme Court, my lord, what will happen? Please declare it unconstitutional if the Parliament enacts a uniform civil code. Now, let them enact a uniform civil code. Then we will decide whether it is constitutional or unconstitutional. You can't be wasting our time. Similarly, can bills be challenged before the court? No. Acts can be. Why? Because bills are related to hypothetical situation. What if the bill is not entirely passed by the Parliament later? You are wasting our time. The power of judiciary to review its own judgments given earlier in similar or different cases. Yes, that's also judicial review. But we have to then see which is the correct answer or the most appropriate answer. And the most appropriate answer is A. And A is the answer because judicial review is not only about laws passed by the legislature. It is also about the rules issued by the executive, because the fact check unit that I was talking about was not a law. It was a rule made by the executive. So the correct answer or the most appropriate answer is A. Right? Okay. 99. Which of the following or who of the following is the custodian of the Constitution of India? According to the UPSC answer key, it is the Supreme Court of India. Although President takes the oath to defend the Constitution, but according to the UPSC answer key, it is the Supreme Court of India. Now, century, 100th question of this marathon. The power to increase the number of judges in the Supreme Court is vested in Parliament. Because we have Article 124 of the Constitution. Article 124 says there shall be a Supreme Court headed by the Chief Justice of India and not more than 7 judges, 7 other judges, 7 puny judges, 7 brother judges. But can Parliament increase the number of judges? Yes. Today we have Chief Justice of India and 33 other judges. Or these other judges are known as the puisne judges. So who has that power? That power is with the Parliament. And Parliament will pass this law to increase the number of judges, and this law is not a constitutional amendment. This law is an ordinary law. An ordinary law can be passed by simple majority. Why? Although any change that you make to the Constitution means a constitutional amendment, but there are some changes. Constitution has also provided for a lot of flexibility, that even if you make these changes to the Constitution, these changes shall not be deemed as an amendment, which means you don't have to use Article 368 to make these changes, which means you can pass an ordinary law through simple majority to change them. And one such flexible provision is increasing the number of puisne judges in the Supreme Court. This the Parliament can do by passing an ordinary law, because increasing the number of judges shall not be deemed as an amendment to the Constitution. Okay? Great. The power of the Supreme Court of India to decide dispute between the centre and states falls under original jurisdiction. All the disputes between centre and the state, or between states amongst themselves, or between centre and state on one hand and other states on the other hand, all these are federal disputes, and these federal disputes come under the original jurisdiction, which means only the Supreme Court has the power to decide on these matters. Or the better term should be original and exclusive jurisdiction. Sir, what is the difference between exclusive jurisdiction and original jurisdiction? Original jurisdiction means a case can be filed in the Supreme Court directly, not through an appeal, but directly. Exclusive jurisdiction means only Supreme Court has the power to hear and determine that case. For example, can you approach the Supreme Court if your fundamental rights are violated? Yes. But does Supreme Court have the exclusive jurisdiction over fundamental rights violation cases? No. Because you can also approach the High Court under Article 226. So Supreme Court has original, not exclusive jurisdiction over fundamental rights related cases. But can you challenge if there is a dispute between Kerala and the Government of India? This is where Article 131 is invoked. And such a dispute is there before the Supreme Court. If there is a dispute between Kerala and the Union Government, can it be filed in Kerala High Court or Delhi High Court? No, it can be only and only filed in the Supreme Court. Supreme Court has the exclusive jurisdiction over such cases. Similarly, there is a dispute between Karnataka and Maharashtra based on Belgaum. That dispute is pending before the Supreme Court since 2004. That's an original jurisdiction because it involves a dispute between one state and the other. Clear? So C is the right answer. A writ of prohibition. Now, what is a prohibition? A superior court, for example, Supreme Court, will issue a writ of prohibition against a lower court, asking the lower court, you stop proceeding further, halt your hearing. So what is writ of prohibition? Issued by the Supreme Court to High Court or High Courts, to a government officer prohibiting him from taking a particular action? No. To the Parliament or Legislature to pass a law on prohibition. In fact, Parliament cannot be directed by the Supreme Court to do something. Although in some cases it has nudged the Parliament to enact a law, but normally it should not be the case. That's a case of judicial overreach. The government prohibiting it from following any unconstitutional policy? No. The answer is a writ of prohibition is issued by the Supreme Court or High Courts to lower courts prohibiting continuation of proceedings in a particular case. That is prohibition. Okay? Okay. What is the provision to safeguard the autonomy of the Supreme Court of India? 2012, but very important question. Constitution has given some independence to the Supreme Court. Like, the judges of the Supreme Court and High Court are appointed by the President after consultation the Chief Justice of India. The judges of the Supreme Court and High Court, they remain in office till a well-defined tenure, till they attain a specific age, because they do not hold office during the pleasure of the President. This is to give them security in tenure. The Supreme Court and High Court, they have the power to punish for its contempt. The salaries of these judges are charged on the consolidated fund. In fact, you cannot discuss the conduct of judges in the parliament unless and until you are bringing a motion to remove a judge. The judges of the Supreme Court and High Court are removed by the President based on a very complicated process of removal. And such is the complicated process that till date, no judge of the Supreme Court or High Court has ever been removed. This is meant to give independence to the judiciary. What is the provision to safeguard the autonomy? And autonomy, we can safely say, means independence. While appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India, correct? The Supreme Court judges can be removed by the Chief Justice of India only? No, they can be removed by the President on the recommendations of Parliament. The salaries of the judges are charged on the Consolidated Fund of India, to which the legislature does not have the right to vote. Yes, if it is Supreme Court judge, it is charged on the Consolidated Fund of India. If it's a High Court judge, it is Consolidated Fund of that state. If it is the pension of the judges, pensions of even High Court judges, it is Consolidated Fund of India. The appointment of officers and the staff of the Supreme Court of India are made by the government only after consulting the Chief Justice. They are made by the Chief Justice of India, not by the government. So 1 and 3A becomes the right answer. Now let's look at questions related to the schedules of the Constitution. If a particular area is brought under the 5th schedule of the Constitution of India, which one of the following statements best reflects the consequence of it? 5th schedule, that means in states other than Assam, Meghalaya, Mizoram, and Tripura. Because for them, there is an exclusive schedule in the form of 6th schedule of the Constitution. The difference is that 5th schedule protects only the economic interests. Economic interests, for example, sale of tribal land to non-tribals. This can be restricted. But 6th schedule protects not only the economic interests, but social customs as well. Culture as well. If a particular area is brought under 5th schedule, what does that mean? What is the consequence? This would create a local self-governing body in that area? No, that is for a Schedule 6 area, autonomous body. Autonomous districts are created. Autonomous councils are created. District councils are created. This was convert that area into a union territory? No. The state having such areas would be declared as a special category state? No. Special category state was decided by the Finance Commission, the 4th Finance Commission, where the Finance Commission said that there are some areas in India, some states in India, because of their hilly and difficult terrain, because they are unable to generate their own resources, we will give them tax breaks. And if there is a centrally sponsored scheme, the central government, the union government will contribute 90% of those funds. While if it's a general category state, the contribution between the center and the state will be in the form of 60:40. 60% would be contributed by the center, 40 by the states. So the consequence of a fifth schedule would be this would prevent the transfer of land of tribal people to non-tribal because your economic interests are to be protected. A is the right answer. The provision in the fifth schedule and sixth schedule in the Constitution of India are made in order to determine the boundaries between states, determine the powers, authorities and responsibilities of the panchayats, protect the interests of the border states. No, it is to protect the interests of the scheduled tribes. A is the right answer. With reference to scheduled areas in India, consider the following statements. Within a state, the notification of an area as a scheduled area takes place through an order of the president, because President of India has the power to establish a scheduled area in a state, to increase the area of that scheduled area, to reduce that area as well. And then the governor has the responsibility to administer that scheduled area. The largest administrative unit forming the scheduled area is the district, and the lowest is the cluster of villages in the block. This is also correct. The chief ministers of the concerned states are required to submit annual reports. No, I told you who has the responsibility to govern, administer that scheduled area. That's the responsibility of the governor. And it shall be the responsibility of the governor to submit an annual report to the president. Sometimes it may not even be the annual report, or as may be directed by president. President may say submit a report now, not necessarily an annual report. So 1 and 2, only 2 statements are correct. B is the right answer. Okay? Great. With reference to the anti-defection law in India, consider the following statements. The law specifies that a nominated legislator cannot join any political party within 6 months of being appointed to the House. You can join a political party within 6 months. You cannot join a political party after 6 months of nomination. Because if you join a political party after 6 months of nomination, you shall be liable for disqualification. The law does not provide any time frame within which the presiding officer has to decide on a disqualification petition. Correct, because there is no time limit. That is why it is liable to be misused, and that is how the speaker, the presiding officer, has misused, because there is no time limit. In fact, that's the reform that we suggest. There has to be a time limit. In fact, that's the Supreme Court suggestion as well, that the speaker should normally act on the disqualification petitions within 3 months. But the law does not prescribe a time limit. Which one of the schedules of the Constitution of India contains provisions regarding the anti-defection? 10th schedule, which was added by the Constitution by the 52nd Constitutional Amendment Act, 1985. Clear? Now let's look at the questions related to local self-government. Local self-government can be best explained as an exercise in, yes, it can be viewed as federalism as well, because what is federalism? Federalism means that powers are distributed between 2 or more layers of the government, center, state and the local governments. But local governing institutions in India, Panchayati Raj, municipalities, they are best represented in terms of democratic decentralization. Power should not be centralized in the hands of the state. It should be given to local governments. And these local governments are elected by the people. That means these are democratic institutions. Democratic decentralization. It is not delegation, because delegation is in the form of what? It can be given to them at any point in time and then snatched as well. You have to decentralize. You don't have to delegate. Yes, it is considered to be one aspect of direct democracy, because this 73rd and 74th Amendment has converted India from a representative democracy to intensely participatory democracy, giving us a sense of a direct democracy where people themselves, through Gram Sabha, govern themselves. But it is not a full aspect of direct democracy, because not all people are involved. It is best explained in terms of democratic decentralization. Okay? Consider the following statements. The minimum age prescribed for any person to be a member of panchayat is 25. Minimum age is 21 years. Statement is incorrect. A panchayat reconstituted after premature dissolution continues only for the remainder of the period. B2 only is the right answer. So a panchayat normal term is 5 years. But what if after 2 years you are dissolved? Fresh election has to be conducted. And when freshly elected panchayat is constituted, it will remain in force for the remainder of the period, for the 3 years. That is what the question is asking. B2 only is the right answer. The Northeastern Council was established by the Northeastern Council Act of 1971. Because States Reorganization Act of 1956 created 5 zonal councils. These zonal councils were created in Northern, Southern, Eastern, Western and Central India. Then in the year 1971, Northeastern Council was created. Not by the States Reorganization Act, but by the Northeastern Council Act of 1971. It talks about the 7 northeastern states and Sikkim, 7 sisters and Sikkim. Then this act was amended in the year 2002. This question was asked. And I think this question was not asked in 2016. This question was asked in 2024. Has anyone flagged this yet? No, this question was asked in 2024. Okay. Because of this amendment, who are the members of this Northeastern Council? Governor of that constituent state, yes. Chief Minister of that state, yes. 3 members nominated by the President, yes. Home Minister, no. Home Minister is part of these 5 zonal councils, not part of the Northeastern Council. So what is the correct answer? A, 1, 2, 3 is the correct answer. Done? Great. With reference to Gram Nyayalay's Act, which of the following statements are correct? We have constitutional courts. Which are the constitutional courts? Supreme Court, High Court and the District Court. Then in the year 2009, statutory courts were created by the law passed by the Parliament called Gram Nyayalayas. And the objective was that Gram Nyayalaya should be constituted so that we can give justice at the doorstep. That means there is Supreme Court for the entire country, High Court for every state, District Court for every district. Now we should have a court for every village as well. But obviously it will be costly to create courts for every village. That is why the idea was that we will have these Gram Nyayalayas in the form of mobile courts, moving from one village to another for granting justice. But these Gram Nyayalayas can hear all kinds of cases, even civil cases as well as criminal cases. If it is a Lok Adalat, Lok Adalats can hear only civil cases. And the only criminal case that a Lok Adalat can hear is a check bounce case. Check bounce case is primarily a criminal case, although there has been a talk that we should remove it as a criminal case. But be that as it may, as per the Act, Gram Nyayalayas can hear only civil cases and not criminal cases. This is incorrect. The Act allows local social activists as mediators or conciliators. This is correct, just like on the patterns of Lok Adalat. So which of the given statements are correct? B2 only is the right answer. Okay, great. The government enacted the Panchayat Extension to Scheduled Areas Act. For example, we have Schedule 6 of the Constitution. Do we have Panchayati Raj institutions in Schedule 6 areas? No. Why? Because already they have a lot of autonomy. Because all the areas in Schedule 6 areas, for example, there are 10 districts in 4 states, 3 districts in Assam, 3 districts in Mizoram, 3 districts in Meghalaya, 1 district in Tripura. which come under Schedule 6. And all these districts are autonomous districts. All these autonomous districts have district councils. All these district councils are democratic, which means election takes place. Which means if every district council has 30 members, 26 are directly elected, 4 are nominated by the governor. These district councils, they have the autonomy. They can pass laws related to their family, marriage, divorce, education. They can also impose taxes, tolls. So they already have autonomy. So there is no point in having Panchayati Raj institutions. But can there be Panchayati Raj institutions in Schedule 5 areas? For that, a law was passed by the Parliament in 1996 called PISA, Panchayat Extension to Scheduled Areas Act. Which one of the following is not identified as its objective? To create autonomous regions in tribal areas, that is not the objective. To create autonomous regions, that is part of the Schedule 6 areas, not Schedule 5 areas. For schedule areas to provide them self-governance, to recognize their rights over minor forest produce, that's the role of the Gram Sabha. To free tribal people from exploitation in the form of their land being transferred to another non-tribal people. That's why PISA was extended to scheduled areas under Schedule 5 of the Constitution. But the intention was never to create autonomous regions in these tribal areas. So C is the right answer. The Constitution 73rd Amendment 1992, which created Panchayati Raj institutions, provides for which of the following? District Planning Committee? Yes. State Election Commission to conduct elections to panchayats, because elections to Lok Sabha, Rajya Sabha, President, Vice President, Legislative Assembly, Legislative Council is organized by Election Commission of India. But elections to Panchayati Raj institutions or municipalities is conducted by a State Election Commission. So that is also provided by the 73rd Amendment. Establishment of State Finance Commission, yes. Every 5 years, the governor of that state has to constitute a State Finance Commission. And then the State Finance Commission will tell us, out of the taxes which are raised, the revenue which is raised by the state government, what percentage of that, what proportion of that is to be shared with the local governments, is to be shared with panchayats? All these are correct. 1, 2, 3 is the right answer. Right? Very good. Now there are finally the last part, some miscellaneous questions that we have to discuss. Miscellaneous questions, something which can't be clubbed under the earlier themes that we have covered. For example, fundamental rights, directive principles, executive, legislature, judiciary, Panchayati Raj. Right to vote and be elected in India is a constitutional right provided under Article 326. Although ideally it should have been a statutory right provided by the Representation of the People Act 1951. But the UPSC answer key says it is a constitutional right. Because right to be elected is something which is provided by the Representation of the People Act. Representation of the People Act 1951 talks about the qualifications for somebody in order to contest elections to the post of MP, so on and so forth. Although yes, right to be elected, we can say, is mentioned in the Constitution as well, in the form of who can become an MP, who can become an MLA, what is the qualification. So be that as it may, it's a constitutional right. Consider the following statements. In the election for Lok Sabha or State Assembly, the winning candidate must get at least 50% of the votes polled to be declared elected. Now, we have discussed this previously, although I think we have repeated this question. We follow first past the post system. So you should get the highest number of votes, not the majority. According to provisions laid down in the Constitution of India, the Speaker's post goes to the majority party. This is incorrect. Which of the statements are correct? D. Neither 1 nor 2 is the right answer. Great. Consider the following statements. In India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. Tricky. In 1991 Lok Sabha election, Shri Devilal contested from 3 Lok Sabha constituencies. Oh my God. As per the existing rules, if a candidate contests in one Lok Sabha election from many constituencies, his or her party should bear the cost of by-elections to the constituencies vacated by him or her in the event of him winning all the constituencies. Apply the same logic as I told you before. If such questions are asked, if such statements are given, don't start preparing like that. Which means now you don't have to look at all the candidates who contested the election and see whether they contested from 1, 2 or 3 constituencies. Which means even if you don't know the answer to that statement, that will not be an impediment in you arriving at the right answer. Here you can use elimination. For example, Mr. Modi contested from Varanasi as well as Vadodara in 2014. He got elected from both. Then did the BJP fund the by-election to Vadodara because he vacated that seat? No. That is the reform that we suggest. That candidate should be allowed to contest election from only one constituency. Rahul Gandhi contested from Raebareli and Wayanad and won both. When by-election was conducted in Wayanad, did the political party, the Congress, fund that election campaign or that election process? No. So C is incorrect. When C is incorrect, 3 is incorrect, so 1 and 3, 2 and 3 cannot be the right answer. So either it is 1 only or 2 only. We also know that Representation of the People Act 1951, it was amended in 1996 because till 1996 you could have contested election from 3 constituencies. Then it got amended. Now the amended law says you can contest election from up to 2 constituencies. Otherwise, Rahul Gandhi would have contested from 3 constituencies because she was not sure that he will win both the constituencies. Then you could have contested from as many constituencies as possible. Which means in India, there is a law restricting the candidates from contesting election from 3 constituencies because you can contest from only up to 2 constituencies. Which means the remaining is 2. B only is the right answer. 2 only is the right answer. Which means yes, Devi Lal contested from 3 Lok Sabha constituencies in 1991 because the law was changed only in 1996. Clear? Very good. If the President of India exercises his power as provided under Article 356 in the respect of a particular state. Article 356 deals with President's rule. The assembly of that state is automatically dissolved. We have discussed that it is not automatically dissolved. It is kept under suspended animation. Article 19 is suspended in that state. I told you President's rule has got nothing to do with your fundamental rights. Your fundamental rights are unaffected. The President can make laws for that state? No. It is the Parliament which becomes the legislature of that state. So the powers of the legislature of that state shall be exercisable by or under the authority of the Parliament. Which means when the President under Article 356 proclaims President's rule, what he does in his proclamation, in her proclamation, she says that the powers of the legislature will be given to the Parliament, which means Parliament will become the legislature, or Parliament can give this power to any other authority, but it is the Parliament's authority. And President will assume to herself all the executive powers of that state. That is the answer. B is the right answer. Which of the following bodies do not find mention in the Constitution? Which of these are not constitutional bodies? Which of the following does not find mention in the Constitution? Is NDC mentioned in the Constitution? No. Is a Planning Commission mentioned in the Constitution? No. Is a Zonal Council mentioned in the Constitution? No. So D, 1, 2, 3 is the right answer. Because this is a statutory body created by the law passed by the Parliament. These two used to be non-statutory extra constitutional bodies. That means these were not even created by the constitution nor created by the law passed by the parliament. These were created by the cabinet resolution, government resolution. Question is asking which of the following bodies do not find mention. All these do not find mention. D is the right answer. Okay. Okay. With reference to the Delimitation Commission, consider the following statements. The orders of the Delimitation Commission cannot be challenged in the court of law. Correct? That's related to Article 329. Tarak N has made an interesting point. The Constitution's 73rd Amendment, which aims at promoting Panchayati Raj, provides for State Election Commission establishment. Yes. Here the answer should be 2 and 3. Because State Election Commission, yes. State Finance Commission, yes. District Planning Committee as well as Metropolitan Planning Committee are provided by 74th Constitutional Amendment Act. District Planning Committee, Metropolitan Planning Committee, yes, you're right. Thank you. Orders of the Delimitation Commission cannot be challenged in the court of law, although there is a 2024 judgment of the Supreme Court where the Supreme Court has said this order can also be challenged if it is malified. But according to the existing rules, we can say that the orders of the Delimitation Commission, if the statement is asked, cannot be challenged in any court of law. Although 2024 judgment, Supreme Court has said if that order is manifestly arbitrary or malified, it can be challenged in the court. When the orders of the Delimitation Commission are laid before the Lok Sabha or State Legislative Assembly, they cannot effect any modifications in the orders. Yes, because the order of the Delimitation Commission is final. C, both 1 and 2 is the right answer. How many questions are left? Just 7 or 8 questions more, then we are done. How many delimitation commissions have been constituted by the Government of India till December 2023? 4. 1952, 1962, 1973, and 2002. 4 delimitation commissions have been set up. Right or wrong? Right. Consider the following statements. It is the governor of the state who recognizes and declares any community of that state as a scheduled tribe. No, that responsibility is with the president. And president does that on the basis of the law passed by parliament. So basically, parliament has to pass a law to add a tribe in the list of scheduled tribes, or to add a scheduled caste in the list of scheduled tribes, scheduled caste. And the president issues an order under the SC/ST order of 1950. So that power is not with the governor, that power is with the president. A community declared as a scheduled tribe in a state need not be so in another state. That's also true. You can be a scheduled caste in one state, but not in another state. So which of the following statements are correct? B, 2 only is the right answer. Okay, great. How many students are here out of 184 who are watching right now, who were here right from the start, right from the time we started this session from 8? Interstate Council is a non-permanent constitutional body. Very good. Kudos to you. 110% you will qualify the prelims examination. Saurabh, I have already clarified that As per Article 368 of the Constitution of India, Parliament may amend any provision of the Constitution by way of what is an amendment to the Constitution? Add something, vary something, repeal something. So 1, 2, 3, D is the right answer. This was the question asked in Prelims 2024. Consider the following statements. According to Constitution of India, a person who is eligible to vote. Now, I want all of you to answer this question, please. You have stayed with me for so long. Now stay with me for 5 minutes more, 10 minutes more maximum. According to Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months, even if he or she is not a member of the state legislature. According to the Representation of the People Act, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting an election even after his release from prison. Which of these statements are correct? Majority have got it wrong. Okay. That's why this is a very interesting question. Let's look at the statement 2 first. According to Representation of People Act, a person who is convicted for criminal offence, there is Section 8 Clause 1, Section 8 Clause 2, Section 8 Clause 3. If you are convicted under Section 8 Clause 1, even if a fine is imposed on you, you are disqualified. Even if a fine. If you are convicted under Section 8 Clause 2, only if you are given 6 months or more imprisonment, only then you are disqualified. If you are convicted for less than 6 months, you will not be disqualified. But convicted for more than 6 months, you are disqualified. And if you are convicted under Section 8 Clause 3, you can be disqualified only if 2 years or more imprisonment is given to you. And in all these cases, you are disqualified till the time you are in jail and further disqualified for 6 years after your release. So this statement is incorrect because it says you are permanently disqualified even after your release from prison. In fact, this is a petition before the court that somebody who has been convicted and sentenced to jail, this person should be disqualified forever. Because if you can't get a government job after getting convicted, how can you be eligible for contesting elections after 6 years of your release? So statement C is incorrect. Let's look at statement 1. According to the Constitution, do you have to be necessarily a member of the parliament in order to become a minister? Or a member of the state legislature to become a minister? No. Even if you are not a member of the Legislative Assembly or Legislative Council, you can be appointed as a minister, but provided within 6 months you have to get elected. You have to become a member of Legislative Assembly or Legislative Council. But who is eligible to vote? Somebody who is 18 years. 18-year-old cannot be appointed as a minister because you have to be eligible to become a member of Legislative Assembly or Legislative Council. For Legislative Assembly, it is 25 years. For Legislative Council, it is 30 years. If you are 18 within 6 months, you can't become 25, which means you can't be appointed as a minister. So this statement is also incorrect. Which of the given statements are correct? Neither 1 nor 2. Right? This is not a minor mistake. This is a mistake. Okay, we adopted parliamentary democracy based on British model, but how does our model differ from that model? In Britain, parliament is sovereign, as is the example that I almost always give in the words of D. Lolme. British parliament is sovereign because it can do anything except convert a man into a woman or a woman into a man. because there is no limitation on the powers of the parliament. There are no fundamental rights binding on the parliament in Britain. British parliament can do everything because it is sovereign. Indian parliament cannot do everything because Indian parliament has restrictions. It is bound by the basic structure. It cannot violate fundamental rights. So as regards legislation, the British parliament is supreme or sovereign, but in India, the power of parliament is to legislate is limited. Yes, limited by fundamental rights, limited by the basic structure doctrine. In India, matters related to constitutionality of an amendment of an act of the parliament are referred to Constitution bench by the Supreme Court. Constitution benches, 5 judges or more. Which of the given statements are correct? C, both 1 and 2 is the right answer. Right? For election to Lok Sabha, a nomination paper can be filed by anyone residing in India, which can also include aliens. So this can't be the answer. A resident of the constituency from which election is to be contested. I think we discussed this previously as well. I think this is a repeat. But if you are a resident of a constituency, that is not a qualification because you can be the resident of another constituency and contest election from a different constituency. Any citizen of India, but what if your name is not mentioned in the electoral rolls? You can't contest election. Any citizen of India whose name appears in the electoral roll of a constituency, that person is eligible to contest. So C is the right answer. We have 2 more questions now. Hold your breath. We are almost done. Consider the following statements in respect of Bharat Ratna and Padma Awards. This question was asked in Prelims 2021. Bharat Ratna and Padma Awards are titles under the meaning of Article 18. Article 18 talks about abolition of titles. Constitution says no title except academic or military distinction can be conferred by the state. In fact, this matter went to the court as well. When the petition was filed in the Supreme Court in Balaji Raghavan versus Union of India, where it was communicated to the court that these Bharat Ratnas and Padma Awards, Padma Vibhushan, Padma Bhushan, Padma Shri, these are used as titles and as such violate Article 18. Supreme Court said, no, these are not titles. Because despite the fact that we have abolished titles, that does not mean merit should not be recognized. Merit should be recognized. So Bharat Ratna and Padma Awards are titles under the Article 18 of the Constitution. No. Padma Awards, which were instituted in the year 1954, were suspended only once. Padma Awards were suspended twice. First in 1977 when Janata Party came to power, because Janata Party said these Padma Awards, Bharat Ratna, Padma Vibhushan and others, these are misused by the ruling political party. Indira Gandhi gave herself the Bharat Ratna. So that is how they were suspended in 1977. But when Indira Gandhi came back to power in 1980, she reconstituted it. And then again it was suspended when the case was there in the Supreme Court to check the constitutional validity of these awards. So these were not suspended once but twice. The number of awards is restricted to a maximum of 5 in a particular year. Although at that time Ministry of Home Affairs had released the rules which said that awards are restricted to 3 awards in a given year. So which of the above statements are not correct? D, all the statements are not correct. Although now since it is part of the rule and rules can be changed at any point by the executive. That is why last year Bharat Ratna was awarded to 5 individuals. Clear? So that has been the change. Yes, and in fact in 1999, Bharat Ratna was awarded for 4 individuals. Last question. Which of the following is the function or the functions of the Cabinet Secretariat? Cabinet Secretariat headed by the Cabinet Secretary. Cabinet Secretary is the senior most IAS officer. In fact, that should be your Motivation. Qualify this exam earlier so that you have a long tenure and you become eligible to become the cabinet secretary, which is the highest post that a IAS officer can aspire for. What is the role of this cabinet secretariat? Preparation of agenda for cabinet meetings? Yes, because in every cabinet meeting, cabinet secretary is present, and he is the one or she is the one who records the minutes of the meeting. Giving secretarial assistance to cabinet committees. Whatever assistance is required to the 8 cabinet committees, that is provided by the cabinet secretariat. Allocation of financial resources to ministries? No, that is done by Parliament. Through budget, annual financial statement. So C, 1 and 2 is the right answer. And that brings us to the closure, to the end of the session. It was indeed a marathon. I thoroughly enjoyed it. And I think so did you. If you did not, I'm sorry. If you did, do let me know in the comment section, and see you again next time with another fruitful session for your preparation. And next Friday, 8 p.m. onwards, we will come up with Bare Act 3. Okay, and this session, this PDF is very, very important. Please keep note of this. Download it from my Telegram channel. The link is provided in the video description. And thank you for staying with me, and all the best. May all your legitimate dreams come true. See you soon. Till then, have a great time. Bye-bye. Good night or good morning.